This wants permission of the matter.
Mike is there. Mike is there.
I'm sorry, I'm sorry. Please, Manoj, this is to move a matter, interim relief tomorrow, Manoj, if Lord's permission, because on the last occasion also we moved a matter, my Lords had said that to comply with all the positions. We already complied with everything, Manoj.
What
All
is
the issues.
What is the urgency?
Manoj, this, Manoj, 200 cafes are shut all across Karnataka. This is not linked with the other hookah matters, Manoj. This, Manoj, we serve only herbal hookah. We are not bound by the notification. It's a different matter, Manoj. It's not because we do not come under the court pact. We do not have nicotine or tobacco in our.
So your hookah bar owner.
Manoj, hookah ban order itself, but Manoj, we are not bound by the notification because we do not have, we do not fall under court pact.
Monday.
It's a different.
Monday.
Tomorrow, Manoj, if possible, please. If possible, Manoj, I think.
Lord's kind permission, mentioning a fresh repetition for urgent posting. The urgency is this: I'm a contractor who constructs the national highway, the Shimoga-Tumkur circle, which runs up to 150 stretch. Now the mines department, which is the respond number 1, has entered the site and they are stopping the work and doing a survey stating that I have to pay royalty.
Let them do the survey.
My lords, the urgency, they're stopping the work and this is the government of India work which I am doing, my lords. My lords, may kindly keep it on Monday, my lords.
We circulated now.
My lord, a PIL which was filed in 2020, because of the intervening COVID period, it was never listed, my lord. May I request for a short date for this PIL, my lord? 2020.
Fresh. Okay. Date must have been given.
No, my lord.
You file IA then.
IA for early hearing is already filed, my lord.
No, you file new interim application for posting early.
IA is already there on record, my lord. I have filed an IA for early hearing also. Only date is to be fixed, my lord.
You want to get IA posted?
Yes, Bandila. No, I am seeking for a date, my lord.
Date for that you file IA.
No, any convenient date may be given, my lord. My lord, only for a hearing on IA, my lord.
What is the subject matter?
Subject matter is regarding fixing of fare meters for taxis, my lord.
Fixing of
Fare meters for taxis,
taxi fares.
taxi fares. Right from 2020, that system is going on, my lord, even though it is mandatory under the rules.
Just it earlier listed once.
It is a different PIL, my lord. That is 2024, my lord.
3rd July.
My lord,
23rd July.
23rd July. Oblige.
My lord, we are law graduates, my lord. We have filed our applications for enrollment, my lord, with the Bar Council. However, a whooping fee of 40,000 had been imposed as enrollment fee, my lord. We had filed a writ petition and there was a very clear interim order for the State Bar Council, directing the State Bar Council to enroll us without any fee as of now on the undertaking that we will pay any fee that is directed by this honorable court, my lord. We have already done it. We have already filed the undertaking with the court as well as with the State Bar Council. Now, there are 3 occasions on which enrollment was done, my lord. However, we have been refused to be enrolled in clear violation of the orders of this honorable court, my lord. Tomorrow is the next enrollment date, my lord. Hence, there's some urgency in the matter if it may be heard.
Why you are here at the last moment?
It has been happening 3 times, my lord. 3 times I've approached them and they've refused.
Monday?
My lord, today at the end of the list or tomorrow on the top of the list, my lord, because tomorrow is the 4th time they'll be approaching with all their documents.
It will last for some days. Enrollment process will last for some days.
This is already the 4th occasion, my lord. They've already refused me thrice.
Every Friday. It is every Friday, my brothers.
Any date may be fixed accordingly.
Next Wednesday.
Wednesday.
My lords,
Obliged.
in the same matter, one kind indulgence, my lord, short indulgence, my lord. Why I'm saying is the royalty is completely exempted under the amendment rules of 2023. The mines department is not considering those rules, my
They are
lord.
not permitted.
It's next week, any date, my lords.
It will come in due course. You file or remove office objection, to be listed. To be listed better earlier than what we said.
Obliged.
Yes.
One matter, serial number 44 in the first list. Seek for Lord 2 weeks time, Lord.
3 weeks. In July, 25th July,
Not interim order is there, Lord, to pay
will be extended.
This is a PIL from 2016, my lord.
So you don't want to mention? Yes, yes.
Serial number 57, man. Permission of a week time may be granted. A week time may be granted.
24th July.
PIL from 2016, my lord. I am for the respondent. There's a threat of demolition to my building.
This is under the Ancient Monuments and Archaeological Sites Act. So our construction was before the site was notified. Now, despite that, there's still a threat of demolition to the buildings. If we may be heard, there's no stay or anything.
Tuesday.
My lord, this is a civil contempt petition, my lord. The emergency is, my lord, the accused has violated the stay order of this honorable high court in the petition, and they have already sold the part of social property. And now they're again keeping the social property to sale.
They are keeping property to,
My lord, they have already sold the part of social property. Now they're again keeping for sale.
it will be listed, file, remove the office objection.
Not that will become infructuous, my lord.
Why?
The petition itself will become infructuous if it
How,
is
how,
sold.
how?
If the machineries of the company, if it is sold, the company itself has to be closed.
Next Wednesday.
My lord, this to serial number 3, my lord. I seek short accommodation for filing memo for withdrawal. My lord, the thing is petitioner is in abroad, my lord. He will return on 20th of July, my lord.
Serial number?
May be listed on 23rd
Serial
or
number?
24th, my lord.
Which serial number?
List to serial number 3, my lord.
Three,
Yes, sir.
three, list two.
Yes, ma'am.
All right.
My lord, serial number,
May be taken on
After 4 weeks,
23rd or
My lord.
24th, my lord.
24.
Please.
list 2, serial number 11, my lord. some-
No, no, no. You did not.
Memo for
mention when.
withdrawal, my lords.
Refused.
Civil law, contempt petition, my lord.
All right, we dismissed as withdrawn.
May I make one
In view
sub-
of the memo submitted. Which
May
is
I
taken on
make
record.
one submission?
Dismissed as withdrawn in view of memo submitted, which is taken on record.
My lord,
This is contempt petition, my lord.
my lord, serial number 49, my lord. For complainant, my lord, we will be filing our reply affidavit. Kindly 2 weeks' time may be granted, my lord.
Lords, this is a contempt petition for non-compliance of the memorandum of settlement in an MC case. It's supposed to be posted for preliminary hearing. Non-compliance of memo of settlement in a family MC case, my lord. Contempt petition for non-compliance.
In due course, yes.
My lord, one submission, my lord. Serial number 45, my lord. I appear for the appellant, my lord.
45.
Yes, my lord. I received the objection statement copy yesterday, my lord. I have to have some instructions from the client and kindly have
24th July.
much of it.
Your lordship, serial number 26, your lordship.
Yes,
I appear for respondent number 9, your lordship. I have to seek instructions and get wakalat in that matter. I appear for board.
but let
Okay.
it be considered. Then at that time, we'll consider your request.
Okay, obliged, your lordship.
It is a PIL of 2016, very old
Yes.
matter.
Yes, yes, your lordship.
Therefore, let us see the subject matter.
Obliged, your lordship.
My lord, serial number 49, my lord. For complainant, my lord. We will be filing our reply affidavit. Kindly 2 weeks' time may be granted. 49.
Hold it. 25th July.
Much obliged, my lord.
This contempt matters, seal number 1, the Neglur Arvind.
Neo, give that dictation. They follow.
My request for plan,
Wait for something.
very well.
Seal number 17,
I am for appellant, my lords.
17.
Nobody is there.
I am for appellant, my lords.
You are there.
Yes, my lord, I am for appellant.
Yes. Where is the appearance? Who appears?
I appear for the state, my lord, along with the additional advocate general.
Appearance. I don't remember the name. Who appears? DR. Or learned senior advocate Mr. DR Ravi Shankar, assisted by learned advocate Mr. Sanso for the appellant, from a learned additional advocate general assisted by learned advocate Mr. Sri Nagaraju for the appellant, learned additional advocate general Srimati Prathima Honnapura, with learned additional government advocate Srimati Nilofar Akbar for respondent 1, 3 and 4, and learned advocate Mr. A.C. Balaraj for respondent 5. The present appeal was directed against judgment and order dated 22nd January 24 of a single judge. Whereby learn a single judge not judgment, only order. Order of learned single judge, whereby learned single judge, whereby the petition was disposed of by observing that the elections to the board of Tumkur Cooperative Milk Producers Societies Union dash dispute number 5 hearing should be held before the intended date of election, which was 4/7/24, completing all the procedures for the purpose. Full stop. The term of the board of dispute number 5 society was for period of 5 years, from 2023 to 2028. Did it petition? It was pleaded by the petitioner, appellant hearing. That the respondent 5 was a secondary public federal cooperative society comprised of 1380 members of its primary cooperative societies. Full stop, registered under the Karnataka Cooperative Societies Act, the elections were held for the term of 2018-2023 and thereafter for the subsequent terms of 2020, of year 2023 to 2028. And the next elections for the term of 2023 to 2028 were due. It was stated that the petitioner gave representation and passed resolution dated 18/5/23 for conducting of elections. The prayer was made requiring the respondents to conduct and complete the elections to the Board of Management of the society for the said term of 2023 to 2028 expeditiously. Within 13, within the time of, or expeditiously, or within 13/12/23, as the 5 years were liable to be computed from 14/12/18, which was the date of assumption of charge of appointment of the president of Respondent High Society. The petition was filed on 26/10/23, which culminated into aforementioned order dated 22/1/24 of law in single judge. Full stop. Notice was issued,
Please, my lords.
notice was not issued, notice also. In course of the hearing of the appeal, the present appeal, the following order came to be passed. During the pendency of the appeal, from a learned senior advocate for the appellant, produced notification dated 13/3/24 issued by the government of Karnataka, whereby the term of the office of the members of the board of the Cooperative Society came to be extended in view of the impending general elections to the parliament. Full stop. It appears that the election program was not notified, for which, submitted learned additional record general, was due to the fact that the general elections to the parliament were being held, and the term of the board members of the society had expired, awaiting the fresh elections. The aforesaid notification, however, came to be rescinded by subsequent notification dated 16/3/24. Full stop. The matter rested there. The said aspect was noted. The said development was noted in the orders dated 18/3/24 and 8/4/24. Full stop. As recorded in 8/4/24, learned additional advocate general was required to take instructions about holding of elections, which were already due. Paragraph. The proceedings of the appeal witnessed the following order dated 28/5/24. That order to be quoted is red flag. Thereafter, the rejoinder affidavit was filed. In the rejoinder affidavit, it is inter alia contended that despite notices.
It's only additional documents, my lords.
That's
Not
an additional
document.
document, my lord, dated 14/6/24. That is an additional document, my lord, which I produced.
Argued the matter 4 times. Haven't you argued the matters more than 4 times?
No, my lord, it is not a rejoinder of it,
Now
my lord.
we are in the middle of the dictation of the order.
Yes.
Any interference in the dictation order will not be tolerated. For the simple reason that it breaks the chain of thoughts of the judge. We are within the control of every fact you submitted, every fact which forms part of the record.
No, my lord,
So
I
please
accept.
do not interrupt when the order is being dictated. If there is an error in the order, appeal is available. Or you want to suggest something at the end of the order. It's not in the middle of the order.
Please, sorry.
Please sit down. Please take your seat. The first, as far as this court is concerned, the first observance of the rule is that when the order is dictated, nobody should interrupt. Because it will not permit my mind to run further if you go on interrupting the orders. What did you write? Issued time and again. Under which section? 28A.
Please.
28 of A of the Cooperative Societies Act for holding the elections, elections were not held, learned counsel, senior counsel, along with the assisting counsels were vehement enough to submit that the term of the board of the Cooperative Society had expired long back and the elections were ever overdue. Full stop. It was submitted that the term could not last any longer and the elections were imperative to be held. Full stop. On the other hand, learned additional advocate general and learned additional government advocate submitted that they were not the multiple notices, but it was the process of commencing the list of preparation of list of voters and notices were sent to all in that regard. Full stop. It was submitted that while the authorities were inclined to hold the election at the earliest, what intervened was the event of parliamentary elections then being held, which prevented the authorities to notify the program immediately as the administrative machinery was engaged in the election work and the elections, and it was not possible to hold elections of the board simultaneously with the ongoing parliamentary election. Full stop. The having considered the legitimacy of the ground advanced by the authorities for being unable to hold the elections during the parliamentary elections, the court granted time. Full stop. The court granted time, however, requiring the authorities to come out with the election program at the earliest. Paragraph. In course of the hearing, the hearing learned additional advocate general pointed out that the election program has already been. Where is that? Notified by the competent authority.
28/5/24.
The program is notified and underway is as under this entire paragraph. The stages contemplated in the aforesaid timetable of election are in accordance with the Karnataka Cooperative Society Rules 1960. The time period which is required for considering the objections to the insertion of the names as in the list of voters for hearing and disposing of the objections, comma, for draft voter list publication, and the time gap between the draft list and the final list of voters and the publication of final list, etc., are all statutorily fixed. Full stop. The program is accordingly notified. The date of election is provided to be 10/11/24 after the completion of all the statutory stages. And the date of election of office bearers would be 24/11/24. Full stop. A grievance was sought to be raised by the appellants that the election ought to have been held early, and that the court may upset the election program and direct the authorities to come out with fresh program to complete the elections before well before, full stop. Well before, as the term is already over and the elections are overdue, full stop. The election schedule has already been commenced. The stages have started from the month of May 2024. The dates are fixed to provide the different stages as statutorily fixed. Full stop. Any interjection in the election program at least would on the contrary unsettle the elections which are already underway. Full stop. The court paragraph would be always disinclined to interfere with the election process. Full stop. When the timetable is already notified and the election schedule is declared, comma, no further order is required in this petition. Full stop. Fixing the timetable of the election is ultimately in the domain of the election authorities. Full stop. The court does not find that any serious irregularity was committed in notifying the election after the expiry of the elections, in view of the fact that the elections could not be notified and held because of the ongoing parliamentary elections. Full stop. With the aforesaid reasons and discussion, comma, no case is made out for any further any interference in this in the order. No case is made out to deal with the present appeal any further. The appeal is accordingly disposed of. Anything you want to add, then you tell now.
Okay, and when dictating, it's notify that rejoined affidavit, my lord. That is not a rejoined affidavit. That is a document we have put it on.
Which document? Rejoined law. Like,
It's not a rejoined affidavit. That is in list of documents.
so you want to make a
14.6.
mention of it? Yeah.
14.6. 14.6/24.
So you want us to mention your contents?
That's it, madam.
Let us see.
That
Which
is in oversight.
contentions?
That is not a rejoined affidavit. That is on.
Which contentions?
It's page number 68, madam.
60?
62, madam.
62.
Please.
What is it about?
That is in election authority pass an order to issue fresh notice.
Huh?
The election of commissioner in order to issue fresh notice, that indeed, madam. After that, they issue notice on.
So notices were issued on 12/12/23, 29/1/24, 16/5/24 under 13D to 1. You want to mention that?
29/1, madam. Dated 29/1/24, madam. There is notice, madam. Before,
Will note your contention about these notices, which amounts to prolonging the election, according to it. We'll add the contention and answer it.
Please.
Same answer because of ongoing elections of parliament, but we'll take note of. Yes, we'll add this.
please.
Thank you very much.
Grateful.
They went to find Pilsing versus state of Union.
This. Cell number one.
There is a, madam, there is a judgment
Please, my
we could not find.
please,
Bhim Singh versus probably state of Jammu and Kashmir.
please.
It is in terms said that unless in the rare cases, the fixation of the timetable of
Should not be
election, we
interfered.
always lies with
Please.
the authority.
I'll place it on record.
If available, it's
Please.
all judgment, 3 paragraph,
Please.
3-4 paragraph.
Bhim Singh
In
versus
relation
state
to
of,
the Jammu and Kashmir State
please,
Assembly election.
please, grateful.
For complainant. There is non-compliance of direction number 3, which is at page number 14.
Notice returnable on 5th August.
Cell number two. To Padmanabh R.
It's compliance affidavit. has
Compliance?
been-
Yes, madam.
Complied with
Complied.
learned advocate for the contempt petition stated, Mr. Padmanabh R stated that the directions under contempt are complied with. The spectrum of compliance was confirmed by learned additional government advocate, Ms.
Pramodini Kishan.
Pramodini Kishan. In that view, nothing survives in the present contempt proceedings, they are disposed of accordingly.
Cell number three. To Aditi Shaya.
Notice, nobody is there? Keep back.
Cell number four. To Mohammed Tahir. Cell number four.
Keep back.
My lords, in serial number 3, I am compliant, my lords.
Which matter?
Serial number 3, my lords.
3 notice returnable.
My lords, one submission, my lords.
Oh,
The respondent have filed a writ appeal in the same order which I challenged.
writ appeal is filed. Then
yes,
to be
my
listed
lord.
with writ appeal, it was stated. Yes,
275/24, my lords.
yes, Mr. It was fairly stated by learned advocate for the contempt petitioner, Mr.
Adavishaya.
Be that in respect of the order brought under contempt, writ appeal is filed by the other side. In that view, the present contempt petition shall be listed along with the writ appeal.
275/24, my lords.
4,000 of
275/24, my lords. Writ appeal number 275/24.
all right.
Much obliged.
On 16th of July.
Number five. Mr. Uchappaje.
Complaint in this case, my lord, the non-compliance of the order dated 4th July 2023. In the accused number 1 and 2 are directed to mutilate the entire revenue records in the name of the complainant, my lord. Page number 17 is the order. And page number 21 is the relevant portion of the order.
The directions of learned single judge which are brought under the contempt jurisdiction of this court, read as in the paragraph 4, mark portion, full stop. On bare reading thereof, it is notice that for the purpose of complying of the same, comma, no time limit is fixed by law in a single judge. Full stop, paragraph. When no time limit is provided for, within which the authorities may comply with the directions, comma, it is not possible to come to a conclusion at this stage that there is any willful contempt on part of the authorities in not complying with the direction. Full stop. However, since the directions of the court cannot be left uncomplied with, comma, by providing that the authorities shall comply with the directions of law in a single judge in 6 weeks from today, failing which they will be exposed to contempt jurisdiction, comma, the present proceedings are disposed of. Within 6 weeks, they will do that.
Please.
Number 6, Mr. Prakash M.
For the complaint matter, I have filed the memo for withdraw the county. Permit to withdraw the.
Withdrawing. Yes. Learned advocate seeks permission to withdraw the present contempt petition dismissed as withdrawn. Memo in that regard is taken on record, dated so and so.
Number 7, Mr. Prasanna Kumar P.
Lord's violation of the order dated 12th April 23. Page 28, not is the order.
It's the interim order.
The order which is brought under contempt jurisdiction is dated. Nothing, 17th March 2023.
Not 12th April 23, not on page 20.
Reading as under, quote the order, page 23. Full stop. Learned
I'm-
single judge has granted interim protection in light of the fact that in similar matters, such reprieve has been granted. Full stop. In the first review, comma, no interference is called for. Full stop, dismissed. All other rights and remedies may be worked out with learned single judge.
Please.
Number 8, to Shrikant MP.
Notice returnable on, please, 5th of August.
This is number 9. Dr. Sakesh Shamu Party in person.
My lord, it's regarding the non-compliance of an order at Annexure A, my lord, page number 13. It's very clearly mentioned that I have to be continued as professor with all salary and emoluments.
Your party in person.
Yes, my lord.
An interim order
So what is the interim order?
to continue.
But,
In the
what is
interim,
the breach?
in page number 13, my lord, and 14 and 15. 15 and the page number 14, it is very clearly mentioned that I should be continued as professor. However, as in charge principal, I am not entitled. And on page number 15, my lord, it is prayed to stay impugned order dated so and so, bearing number so and so, at Annexure A, so far as the petitioner is concerned.
So you
And
want
direct
to
the respondents
continue-
continue the services.
You want to continue in employment
Yes, my
up
lord,
to-
with all salary and emoluments.
up to 60 years,
65, my lord.
65 years.
As per AACT.
Today you are in service?
Yes, my lord. I have been going and there and signing
What is-
attendance.
What is the breach then?
No, here they have not paid me, not given me workload and not paying salary also since 1/9.
That can be paid if you succeed in the main appeal.
But my lord, how can I survive, my lord? There is a interim order to be as professor.
Why you are retired, Mr. Council?
No, my lord, I am not retired. By virtue of this interim order, which very clearly says I have continued to be as professor. I am continued till the disposal of that. And also, I approached Supreme Court, my lord, because there was an interference with regard to my in charge principal post. Because there, by virtue of Supreme Court judgment only, I had become the principal of the college. At Annexure E, my lord, page number 269, I approached Apex Court, and there they said, if they have not complied with, you can approach the Honorable High Court. Page number 269 and 270, my lord.
So you are holding, you are serving as what?
My lord. Page number 269, my lord.
Serving as what? You are serving as on which post?
Professor's post.
Professor.
Yes, my lord.
And is there any order permitting you to continue up to 65?
Yes, my lord. That is what is on page number 14, my lord. Page number 14.
65, wow, where is that?
I'll read out, my lord, for your
Read that.
page number 14, my lord.
Read.
Order. It is also admitted that all parties are applicability of All India Council for Technical Education regulations in respect of age of superintendent subject matter of reference before division bench. It is also admitted concern for there about 14 to 15 so and so. And an interim order.
Where is 65 that you are entitled
Here,
to?
I'm coming down, my lord. The next paragraph, it is also admitted that in the matter which has been referred to the division, there was an interim order permitting the petitioners therein to be continued in service despite attaining the age of superannuation. It is further admitted in respect of employee of this very same, there was an interim granted with this which enables continue the age of 60 years. In view of this admitted position, the present petitioner shall also be entered continuous professor. However, he will have no right to continue as in charge principal, so and so. Since it is stated that the issues involved in this writ petition are subject matter, so and so, it is attached clubbed with that, my lord. And my prayer in that writ petition in which I got this order is I mentioned in the synopsis, my lord, or in the writ petition itself I have enclosed, my lord. In the synopsis also my prayers are there. There it is very clear that my services have to be extended from 60 to 65.
Where is the order granting you, permitting you to continue beyond 60 years?
Page number 14, my lord.
No, it is not the order.
Here.
It on the contrary records that it is further submitted that in respect to the employee of the very same institution, there was an interim order granted by this court which enabled him to continue despite attending. Where is that order in your case?
My present petition is me only, my lord.
No, we want an order, Mr. Party in person. Order which is committed breach of.
My lord, this particular case at Annexure A, where this interim order is given to me, I mean passed by the Honorable High Court.
There is no.
In my favor, my lord. Page number 14, my lord. Continue despite attaining the age of superannuation of 60 years.
No, in the order, where is the stay order? Or where is the interim relief granted to you to allow you to continue beyond 60 years?
Yes, my lord. Here, my lord. Page number 14, my lord.
Read it.
I am reading it, my lord. Order, second paragraph, my lord. It is also admitted that in the matter which has been referred to the division bench, there was also an interim order permitting the petitioners therein continued in service despite attaining the age of superannuation. It is further admitted in respect of an employee of the very same institution, there is an interim order granted by this court which enables him to continue despite attaining the age of 60 years.
The case of the petitioner herein?
In view of this admitted position, the present petitioner.
The case of the petitioner on the basis of the order dated 29th August 23 of Learned Single Judge is inter alia that he is permitted to hold the post of professor even after age of 60 years to be entitled to continue till 65 years. You are there or not in service?
I am every day going to the college. There is an attendance register kept for me.
You are in service?
I am in service, my lord.
Now, it is stated that the order.
But my salary and workload has not been.
You are in service or not? We
Yes.
answer whatever we ask.
Yes, my lord.
Everything else we know.
Yes, my lord.
So whether you are in service pursuant to this interim order? You are in service or not? You are serving or you're going to discharge your duty or not?
No, I am not discharging my duty, my lord.
Why?
Because they have not allotted workload to
That
me.
is what we are asking from the beginning.
Yes, my lord. They have not allocated workload to me,
That
nor
part is
paid
what-
salaries to me.
The honored part in person submitted that the aforesaid order is breached and he is not permitted to attend the duty, neither he is paid the salary, full stop. Although the order is interim order, since it relates to and infringes the existing rights flowing therefrom, existing rights of petitioners flowing therefrom, in that way, has the wrapping of finality from a notice to the respondents returnable on.
Regarding salaries, can they
but
release my salaries?
16th
Since first of September, 9 months are over. No sal, nothing. Can they?
We'll see once they come, we'll ask them to pay 16th of July.
Thank you.
Number 10,
Appearing for complaint.
R.P. Somshekaraya.
Complied with,
Complaint, I am appealing for the.
complied with or not complied or not to be complied with. What is three options? Complied with or not complied with or not to be complied with.
Please, madam.
What is to be complied with? Fourth. Yeah.
That they have not complied the order of the Sam court, my lord. They have not, they
What
have
is that?
not restored the revenue entries in the name of the petitioner, my lord.
Which directions to be complied with, Mr.
Well, lordship kindly turn to page number 12, my lord.
Watch out.
Consequently-
Read it.
Consequently, writ petition is allowed the impugned order passed by the assistant commissioner and when the consequential entry made in the revenue records and are hereby quashed and said the revenue entries shall remain as they were prior to the impugned order till disposal of the regular appeal find at the hands of the petitioner in order accordingly. So earlier, my lord, my name was there in the revenue entries. They have changed the revenue entries in the name of other respondents, my lord. But therefore, my lord, writ petition came to be allowed, directed to restore the revenue entries in the name of the complainant, my lord.
Not restored.
Well, that is my lord. The revenue entries shall remain as they were prior to impugned order.
Not restored.
But my lord, the specific direction is there to revenue entries as they were earlier in the.
We are asking it is restored or not restored. It is not.
But the words, the revenue entries shall remain
It is not
as they
kept.
were prior to the impugned order.
It is not kept as it is. It is not kept or kept.
No, my lord, they have not kept as it is, my lord. Earlier, my lord.
How do we show, demonstrate it?
But I have produced the, my lord, in fact, my lord, in this regard, my lord, lordship can turn to
Learned counsel submits that despite the directions of learned single judge in paragraph 4 of the order, the revenue entry in question is not kept as it stood prior to the impugned order. And therefore, there is a breach of the directions. Notice returnable on 6th of August.
This is number 11.
For the complainant,
Notice returnable on 9th of August.
non-compliance of.
Notice returnable 9th of August.
Still number 12.
9th of August.
12 Murthy K.
Serial number?
12, my lord.
9th of August, notice.
Still number 13.
9th of August, notice.
Still number 14.
I appear for the complainant, my lords. My lords, in this complaint, the accused has deliberately not complied with the orders of the Honorable Trial Court, wherein, if my lords may kindly peruse ink page number 40 at Annexure D. On 11/8/2023, my lords, the Honorable Trial Court had mentioned that the accused has not got the child before the Honorable Court.
Go before trial court.
I understand, my lords, but the problem is, if
You are smiling, therefore you are going.
no, man, I have to bow down to this Honorable Court, but my humble submission is this, my lords. I can exercise my rights under Contempt of the Courts Act before this Honorable Court. Before my learned trial judge, I'll have to file an execution, my lords, which is again a burden to the Honorable Trial Courts as well, my lords, with already there being a bulk load of matters. Please, my lords. Much obliged, my lords.
Number 15, Harish NR.
Direction is page number 13, my.
Okay, sir. Number 16, Mr. Satish K. Number 16,
Appearing for complainant, my lords. Please, my lords. Great.
17, disposed till number 18, this green bench matter. Aditya Chandan Gowda.
As I appear for the petitioner in this case, my lords, there are certain facts that I need to put out before this court before I come to the impugned order, my lords. The respondent number 5. The respondent number 5 is a mining partnership firm that had been established in the year 1992, my lord. Now, in the year 1995, the petitioner was incorporated as one of the partner in the partnership firm along with her other brothers and sisters, my lords. In the year 2011, the partners of the respondent firm enter into an unregistered partnership deed. And subsequently, in the year 2016, they obtain a mining lease without showing these documents that are registered in the year 2011, my lords. In the year 2016, they are produced, they are given a mining lease for the next 50 years, my lords. Now, I make various representations to the authorities saying that these unregistered deeds, which are subsequent from 2011, have not been registered or not have been brought to the knowledge of the competent authorities, your lordship. And then I sent a representation. The representation is at Annexure L, your lordship. Please, my lords. Please, there is a civil dispute that is pending, my lords. But I'll bow down to your lordship. But the only concern is that I'm asking the respondent authorities to take action. Please, my lords, I bow down to this lordship, but I only say that because the liability will be fastened on me tomorrow when I succeed, because none of the provisions of Rule 61 or Rule 4R of the Partnership Act are being followed in these mining operations, your lordship. And there is a specific finding of the District Registrar of Firms that Rule 4R and Rule 11R of the Karnataka Partnership Rules have not been followed, your lords. And the impugned endorsement at Annexure Q, that is the page. I am one of the partners who have been removed fraudulently by an unregistered deed, your lordship. Writ petition, my lords, I am challenging the Annexure Q that has been the endorsement. My lords, the right I would. Please, my lords, I have only filed it before the civil court. It's the only concern is that, my lords, Rule 61 is not being followed. So it mandates that the 61 of the Atomic Mines and Minerals Rules, 2016. Rule 61, change of name, nationality, etc. to be intimidated. An applicant for or the holder of a mineral. Rule 61, my lords. Of atomic mines and minerals other than atomic and hydrocarbon energy. My lords, I have culled it down for your lordships at page 19, your lordship means. I've culled down the rule. It's reproduced at page 19. 19 of the writ petition. At the bottom. Please, my lords. Rule 61 reads as for. Rule 6, minerals other than atomic and hydrocarbon energy minerals concession rules 2016. Please, my lords, in paragraph 12 at page number 14, I have stated that. Please, my lords. Change of name, nationality, etc. to be intimidated. An applicant for or the holder of a mineral concession shall intimate to the state government within 60 days any change that may take place in his name, nationality, or other particulars furnished peace. And in the case of continued contraventions of the provisions of Sub-Rule 1, the state government may terminate the mineral concession, provided that no such order shall be made without giving the concession holder a reasonable opportunity of stating the case, my lords. So it mandates that, my lords, see, now, my lords, in 2011, they entered into an unregistered partnership. There is, my lords, there is an interstate dispute between the partners, and the partner, one of the partner, that is the petitioner, has been removed from the partnership. I am the plaintiff, your lords. And I have been removed, and that has not been brought to the notice. No, my lords, that is not, because my remedies there would be totally different, would be to get salary and there to reinstate me and hold the 2011 deed as illegal, and this one to set aside. Please, my lords. Please, my lords, deed of dissolution. Prayer here is to take action against the respondent firm, because tomorrow the action will be taken upon me if I succeed because, and the mining lease may be cancelled if any irregularity is found out, and I'll be put to loss and hardship, your lord. It is not only the thing, and it is also illegal as per Rule 61. So it is illegal mining in reality, my lords, because it's not been carried out in accordance with the rules and regulations that are prescribed, your lordship. And even in the
But there's no change of name or nationality to apply Rule 61. Rule 61 is not applicable. Last may kindly come to page number 250.
Please, my lords.
But
Please, my lords, it does, my lords.
my submission is, it was granted in the name of Mezzas Veerabhadra Sangha Fund Company. The name of the company remains intact. It is the interstate dispute between the partners. Your lordship may come to page number 256. They have filed a company petition also. There was an order.
Please, my lord, the mining lease will be cancelled, and if the authorities are not, and there is a particular finding of the government only at page number 186, Please, my lords, the mining lease can be suspended as per Rule 61, my lords. Rule 61 says that the state government has the power to cancel the rules.
No.
My lords, no, because if there is any irregularities found, because there is a finding
There
of
is no irregularities. That is
kindly
what
see
is the order.
page number 186. Kindly see page number 186, your lordship, for your kindly, my lord. This is the endorsement that's been given by the Inspector General of Firms. Yes, ma'am. 186, my lords. This is an endorsement given by the Inspector General. The translated copy is at page 188 for your lordship's kind perusal, my lords. My lords, in this, by me, my lords, by the petitioner itself. By the petitioner itself, there is a categoric finding that all the partnership deeds that have been registered after 2011 have all been done in violation of the Karnataka Partnership Regulation rules, and act, my lords, and all the rules and regulations have been violated. So that indirectly hampers the Rule 61. Tomorrow, if they come behind the mining company and say that you have carried out illegally, as of now, it was not brought to light. I have brought it out to light. Please, my lords, I request them to consider my application and pass necessary orders with respect to that mining lease, or call upon them to show it, because they are running the mining. My lords, they have not registered any of the deeds pursuant to 2017 in accordance with law, my lords. And they have used 2008 deed to get the registration.
May I make one submission? 256, page number 256. That is the order under challenge.
Please, ma'am.
No, if he is aggrieved, there is an revision provided under section
My lords,
30.
this doesn't become an order. There's no order, my lord. This is an endorsement that's.
There is an order in 256, your lordship. It starts from 255. This is under challenge. Annexure Q.
Yes, my
That is
lord.
what, that is under challenge. In the very same order, in 256 second para, as per the reply submitted by the lessee, it is observed that Srimati Lalita, so and so, has filed OS number before the civil judge and JMFC Sandur against Mrs. Srimati K.S. Ratnam and others for declaration and injunction. Said suit, she challenged the validity of partnership deed dated so and so. In the said, she sought other consequential relief. She has also filed OS number 433 of 2020 against K.S. Ratnam and others before the principal civil judge and JMFC Bellary for declaration injunction. In CMP 100009 of 2020 filed by Srimati.
Please, my lords. Please, yes, my lords. $255 is just an endorsement that has been issued on my representation, saying that since it's an internal dispute, I do not find it deemed fit to think. I'm being aggrieved by that.
The contention regarding availability of alternative remedy may be kept open. Yes. Consequence.
Wait. Please, my lords, 3 years of, 3 years, 3 years. You have to take that.
Bill number 19, filed by government.
Lord, I appear for the appellant, my lord. My lord, here my lord, the learned single judge, my lord, by his order, had, my lord, struck down the provisions of the Karnataka Private Aided Institution Employees Regulation of Pay, Pension and Other Benefits Act, my lord, against which, my lord, there are several other writ appeals that have been filed and are pending before my lords, my lord. This may be clubbed along with the writ appeal 2476 of 2015. An interim order has been granted on 27/11/2015. My lord, 27/11/2015 and my lord, the last page, my lord, last. Yeah. Lord, because of the contempt proceedings, my lord, there's a delay of 2020 days, my lord. Yes. May be clubbed along with 2476 of 20. Obliged, my lord.
Number 20, to Sridhar K.
My lord, I appear for appellant employer company, my lord. Subsequent to filing of the appeal, I got some health issues. My lord,
Your lord.
my lord, I'm audible, sir. My lord,
May I make a mention, Your Lordship? The counsel on record,
Ma'am.
Sridhar K, who is appearing through VC before your lordships, after filing this appeal, he has got some health issues. So and he has expressed his inability to go on with the matter. In that view of the matter, the appellant company has instructed me to go ahead with the matter, but I'm yet to file the wakalat and also. So may I request for an accommodation of 10 days, Your Lordship, to do the needful.
Number 21. Appeal by the department. Amit Deshpande.
My lord, the appellants are aggrieved by the order of quashing passed by the Honorable Single Judge. It is recorded in the impugned order that there is non-compliance of section 42 subsection 2 of the NDPS Act. The respondent herein was arrested and was the main petition was for quashing the complaint that was filed by the Directorate of by the Customs before the Special Court. It was filed by the accused. He was arrested and he was found in commercial quantity of the psychotropic substance. And only on the footing that 42(2) of the NDPS Act, that the reasons are not communicated to the superior officer, my lord, the proceedings come to be quashed. It is germane to note that the accused was arrested during the course of investigation and he was in custody. Prima facie case was made out. And contrary finding is recorded by the Honorable Single Judge that that is a departure of section 42(2) of the NDPS Act, which is totally incorrect. And it is a settled principle of law that, my lord, whether there is a compliance of section 42(2) of the NDPS Act, it is a matter of evidence. And it is quashed and he was in custody and we mentioned this matter and he may be run away from this jurisdiction of this court also. So therefore, my lord, the department has presented this appeal and I may be permitted to serve the advocate who has appeared him before the Honorable Single Judge. And my lord, the date may be fixed for early hearing. Now it is quashed by virtue of this. Yes, my lord, the complaint was on pending and it was set down for charge. It could. I'm sorry. The filing of the complaint and the order of taking cognizance on the ground that there is a departure of section 42(2) of the NDPS Act. Quashed it. My lord, now he was in custody. Now by virtue of this, very short date, my lord, 10 days. I'll serve the learned advocate. I may be permitted to serve the advocate who had represented. delay of 26 departmental appeal. There is a delay, my lord. It can be taken up along with the main matter, my lord, because we had to take the. Since, my lord. At 2:30, my lord, very short point is there, my lord. To Mr. C.V. Nagesh, office of Mr. C.V. Nagesh. May Aditya Kadkod, Ajay Kadkod. Ajay Kadkod. And even, my lord, the records were produced before the Honorable Single Judge. Even the and even we pointed out, my lord, the finding that section 42(2) is not complied. We had produced the record. Contrary finding is given. My lord, may I request one more indulgence, my lord? Since only one point is there, whether 42(2) is a. May I request it at 2:30 on 8th of July, my lord, so that I'll serve them well today only, so that trial can go on subsequently if subject to further orders of this court, my lord. I will serve, my lord. My lord, may I request it day after tomorrow, my lord, I'll serve them. Yes, my lord, today only I will serve. Day after tomorrow. On Monday, your lordship. Monday, lordship. I'm grateful. Great.
Number 22, Mr. M.S. Devraj. Kindly weak accommodation. Engage the senior counsel. He is waiting. Udayavala, Master. Kindly have next week, Master. Engage the senior counsel, Master. Yes. I am the Devraj, Master. Yes, Master. Consideration of complaints in contempt matters, number 23. Mr. Suyo Gerale.
Here for complainants advocate. On the order dated 29/8, my lord. 29/5. Passed by this honorable court. Yes, my lord.
Yes, sir.
Yes, my lord. Not symbolic, my
Seek
lord.
instructions.
Truthful.
I was directed to seek instructions on what has happened. In this, your lordship, what has happened is the order that is passed, 2 writ petitions were clubbed. There's another claimant for hereditary rights for the temple. So there was a direction by the learned single judge saying that he has to approach the endowment commissioner to have his rights because that is the forum. Now, what has happened is we have initiated the proceedings against that. With regard to the articles that were seized in the Mahajar, we have already given the possession to them for the temple to perform all the rites and rituals. Now, only thing is what he says is all the keys, the account books, and the ornament that belong to the Lord are with the Tehsildar, who is the authority in the state treasury. Now, since there is another claimant and his proceedings have been initiated right now, what we have issued a letter to the complainant saying that you please come take the entire books of accounts, keys of the temple, the sanctum sanctorium and the main temple, except the keys and the jewelry that belong to the Lord will not be given to you. However, it will be kept in the state treasury. And even on special occasions, whenever the ornaments or the things are required, he can draw from the Tahsildar and perform until the other claimants' petitions rights are disposed of. Now, your lordship, I have the letter written to the complainant dated 8/6, I think, to come and take the books of accounts. So he has not come and collected it from the Yes. We have already filed an affidavit in this matter, your lordships. Yeah, I will. I have the memo ready because we already filed an affidavit in this matter, your lordship. Yes, sir. Yes.
Shorted.
Obliged. Obliged. Thank you.
Apply.
Number 24.
So for the,
Be with you, Lata.
In this
my
matter,
lord, kindly please for pass over, my lord, senior.
Lords, in this matter, my lords, may I see, may I make a submission? Lords, state is filing an appeal, my lords, we have already secured the government order. 10 days time may be granted to us, my lords. Obliged.
My lord, but they have not yet complied with the
Number, hearing on interlocutory applications, system number 25, Mohammed Tayyip.
Appear for the complaint seeking for recall of the order to comply with the office objections, your lordship. A typed copy had to be furnished and I couldn't comply within the designated date, your lordships. Please. Please, the order should be recalled, your lordship, the previous order. Please.
Number 26.
I'm appearing for respondent number 4, 5, 6, and 7, my lord. Hope I'm audible, my lord. May I make my submission, my lord?
Appearing for the respondent number 8, your lord.
I am for the petition.
My
Petition.
lord, I was supposed to carry out certain work, my lord, and I was supposed to report within a timeline, my lord. I have not done it, my lord. We are in the process of completing that process, and I have filed an application seeking for extension of time, my lord. That particular application is listed, my lord. There was a direction by this honorable court to the direction to the SESCOM as well as the district administration to provide certain information to ascertain the age of the building which are situated within the 100 meters as well as 200 meters, my lord. We have received documents, my lord. We are in the process of completing that particular process and submit the report before this honorable court. But within timeline, we did not get the information. For that reason, my lord, I have filed an application. In the affidavit, the officer has narrated the circumstances, my lord.
What is, my lord?
The survey, my lord, the
Survey has to be complete.
the survey needs to be completed. They have asked for an extension. There is certain illegal and prohibited constructions in the protected area monument of Sri Somya Keshava Temple, Nagamangala Bank.
My lord, in Nagamangala town, my lord, there is a one protected monument is there. Soumya Channakeshava temple. In the Soumya Channakeshava temple, my lord, within 100 meters as well as 200 meters, there are certain buildings have come up. And that particular building which have come up after the one particular period, I'm supposed to report this honorable court as per the order passed by this honorable court, my lord.
Obliged.
Number 27. Venkatesh P. Dalwal.
Petition by the High Court Legal Aid Services Authority.
For respondent number 6, my lord.
The petition by the High Court Legal Aid Services Authority. Lord, it was a suo motu initially taken by the Honorable Chief Justice, then it was treated as a petition. This subject matter, my lords, is with reference to the maintenance of parks and open spaces in state of Karnataka in terms of the Act of 1985. Lord, your lordship may kindly take the amended petition. 6th of July 2021, I have filed it. There I was directed to include certain prayers. It's a PIL by the High Court Legal Aid Services Company. My lord, a letter was written to the Honorable Chief Justice of this Honorable Court, which was sent to the HCLSC, my lords, to file a proper petition. That is how this present petition is filed. Prayers, my lord, may kindly turn to page 14 of the amended petition. But during pendency, my lords, I brought to the notice of honorable. It could be disposed of on its the next date of hearing. Certain directions are requested by the High Court. So next date, my lords, if your lordships can kindly consider these prayers and direct. Very.
I appear to respond number 3 BDM. I've already filed an affidavit. The total number of parks maintained by the BBMP and the BDM. Certain parks are being maintained by the BBMP, Lord. BBMP has to say.
One of the park, my lords, where the park is completely closed and a multi-story building is put up. This honorable court, when I pointed out, called for the report. Report is very explicit, saying that entire park has now converted into some clubhouse. Very.
This is number 28, to MP Chandrachud.
Hearing for the state moment.
Notice has been ordered on the appeal memo. The respondent number 34579 were not served on 3 occasions. I filed an application for substitute of service by way of paper publication. Please, it is there in the file. Please. Samyukta Karnataka Daily Edition, Bangalore. Samyukta Karnataka Bangalore Edition, Daily Newspaper. Samyukta Karnataka Kannada Daily, Bangalore Edition. Please. 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 Only one is enough, Kannada newspaper. Please. Visitation.
Number 29.
I appear for respondent number 5.
Hearing for respondents.
Appellant in this case, Lord.
Lord, the order of the learned single judge is challenged. The learned single judge, though, comes to the conclusion that the award is not passed in accordance with law and possession is not taken in accordance with law. Please. Lord, the possession is not taken. The possession remains with the landowner. I have got the sufficient material to show before this honorable court that possession is not taken. See, because this, though the notifications were made in the year 1987-89, the possession continued to be with the landowner. He filed a suit for original suit, but that suit came to be decreed. Again, that judgment and decree was challenged. Yes, my lord. Interim relief, they have been status quo to be maintained. Lord, An order dated 23/5/2024, the learned senior counsel for the appellant submits that appellant petitioner has benefit of the interim order of status quo, which was in force till the writ petition was ultimately dismissed, fired order so and so. Some subsequently respond 3 to 4 are attempting to put up construction over the scheduled property. As such, the appellant was constrained to file I number so and so for a temporary injunction. Learned counsel for respondent as well as the counsel for the respondent 4 to 5 seeks to file the objections. It is also submitted till the next date of hearing without prejudice their rights and contentions. Respondent 3 to 5 would not put up further construction on the scheduled property. Their submission is placed on record.
My lords, I appear for respondent number 4, my lords. I am one of the respondent number 5, my lords. My lords, respondent number 5 is one of purchaser of a site from an allottee from the third respondent society. My lords, acquisition in favor of third respondent society, my lords.
No compensation is paid.
It is paid. They have
No
received 50.
compensation is paid.
Lords, they have received the
That-
compensation. That's a consent
my lord-
award.
my lord,
And the
once-
document was produced
No,
before
no,
the
no.
learned single judge, my lord, to demonstrate that the original Katedar, who is the mother of this petitioner, my lord, she has taken 50,000 rupees. And my lords, my lord, it was a consent award which was passed, my lord. Your lordship.
Where is that consent award?
My lord, that consent award, your lordship will get that at annexure F, page 125.
It is there on the record.
Yes. Page 125.
But then why learned single judge said that the award is not passed in accordance with procedure?
Because, my lords, the consent award which is passed, the amount is paid through third respondent society to the landowner. That's the reason.
There, a consent award is there.
It is there, it's there.
That is not the payment
At
in
page
area of
120,
law.
My lords, your lordship,
Now,
when, my lords, one more submission, my lords. When they initially filed the writ petition in the year 2015, my lords, challenging the acquisition, their primary ground was that this consent award is beyond 2 years period. Therefore, under section 11 of the Land Acquisition Act, it must be within 1 year.
what
That was the,
what happened to that appeal?
my lords, that writ petition came to be dismissed 2015. But my lords, in 2023.
That order is on the record?
Yes, yes, my lord, your lordship may kindly see this, my lord. In 2015, their initial prayer in the writ petition was the acquisition is bad in law because of the reason that the consent award is passed beyond 2 years, not within the time stipulated under section 11 of the Land Acquisition Act. But later in 2023, they make an amendment application in the very same writ petition. And then they want to challenge the consent award on the grounds of fraud when their mother is not allowed.
On the ground of?
Fraud,
Fraud.
saying that my mother was not the signatory. My lords, if at all that was their contention, when they filed it in the year 2015, they should have taken this contention. Now your lordship may kindly appreciate. This mother is the original Katedar, mother of the petitioner. She did not challenge to the acquisition. She did not say that she did not receive compensation. Till 2000, my lords, she was happy about it. By the time 2000, my lord, the society had already formed layout, allotted sites. In the year 2000, this petitioner, along with his brothers, creates a partition deed and sees that this particular property which had acquired in favor of third respondent society falls to the share of this petitioner. On the basis of that partition deed, instead of filing the writ petition, calling in question the acquisition proceedings, he files a civil suit. Ultimately, my lord, the matter comes to before this honorable court. This honorable court says, no, you cannot challenge acquisition by filing a suit. Then he files writ petition. That writ petition also he lays challenge under the old act. That also he withdraws. He files fresh writ petition. In the fresh writ petition, he takes another ground. Therefore, my lord, the petition is writ by delay and laches.
Now, receipt of 50,000 is not in dispute.
It's not in dispute.
No. My lord,
He cannot
it is-
dispute now also.
let them produce single scrap of paper for payment of 50,000
Yes.
to the appellate.
That
They have not, your
one
lords may kindly take page 125, the consent award.
in consent order is reflected.
No, it.
Yes, it is
See,
reflected.
notices under section 9 and 10 of the act have been served on the khajadars and anbodars. Though notices were served, one of the interested persons have not filed their claim statement. The next page.
Page 126, my lords.
126 may kindly be taken. Lord, this
Consent.
this is not a consent award in the eye of law. That is the reason why the learned single judge said it is not in accordance with law. The secretary of the society has stated that the compensation amount 50,000 in respect of the land has been paid in advance to the landowner, and rupees 49,000 is due to be paid in respect of the land. The amount received by the landowner is stated to be inclusive of 12% additional market value, 30% of statutory allowance, as per the agreement executed by the landlord Anubodar, while requiring body, he has entered into agreement, giving consent and accepted the advance of rupees 40,000 per acre. Accordingly, consent award is passed. Lord, this is not a consent award because the parties have not given any consent. That's one minute. Let me submit. Why are you interfering? My lord, any amount of compensation paid before the acquisition proceedings are commenced, only after the acquisition proceedings are completed, any agreement can be entered into, any amount can be paid. But any amount paid prior to the acquisition proceedings initiated, it is not the compensation in the eye of law as per that is the settled law. My lord, there are a number of judgments to that aspect. This is a crucial aspect of the matter to be considered by your lordships. This here, I have got the videograph, the Google photograph to show the location of the property. Your lords may kindly see the photographs. Here, the entire land is still undeveloped. The entire land.
Not the same copies.
The entire land is undeveloped. No roads have been formed, no sites have been formed. Let a commissioner be appointed now to verify the fact. See, adjacent to my property, one road is there. Only my learned friend's client is trying to put up construction there in that. Lord, the entire property is like that. No developments have been made, and my client has not given possession. And more so, this settled law that the Indoor Development Authority case, the apex court has made it very clear there should be a panchanama for taking the possession. No such panchanama is made. The possession is not delivered to the requiring body. Lord, here no compensation is paid, no possession is taken in the eye of law. Still the land is a barren land. I got the number of photographs.
My lords, the entire argument, my lords, will be set to rest by only one document, my lords. Annexure R6, page 1099, my lords. Your lordship may kindly take page 1099, volume 3. This very same petitioner, my lords, on one hand is challenging acquisition proceedings. On the other hand, he goes and executes a confirmation deed in favor of an allotee by the society.
For that, I can submit.
That seals the issue, my lords.
My learned friend is making the submission
Page
that
10.
my learned friend is making the submission that there is a consent award. Consent what is that, consent document is executed. Confirmation deed, yes, I admit that. Because the title now is transferred from my client to his client by virtue of that deed of confirmation. Your Lordship may kindly see the photographs, how the date of taking the photographs, the entire land, 2 acres and that is still undeveloped. Now the sporadic attempts are made to put up construction.
Prima facie, upon hearing the learned counsels for the respective parties, it appears that the only issue that needs to be addressed in this appeal is whether the award is passed in accordance with law. Although it is the case of the, it is a specific case of the respondents here in that consent award was passed and thereunder the compensation of the 50,000 was paid to the owner of the property. First of the appeal shall be listed for final hearing in the week beginning from 2nd September.
Lord, the interim order may.
Interim order, it is there?
Yes, yes, my lord. I read.
Will not, then will not.
Yes.
Then
Dated 23/5/2024.
we'll fix it early. We'll fix it early. 24th of July. Finally dispose of 20.
Yes, yeah, that could be better, my
May I
lord.
make
That
one
could be
request,
better.
my lords? May I make one request, my lords? Let it be in this stage itself, my lords, with an understanding, because it may not reach if it is for final hearing. May I request it, let it be in this stage, my lords. so
You may
that-
be right. At this 20, then let it be earlier.
Yes, my lord.
We'll think it over. 18th July.
Interim order to be.
In the same stage, my
Not,
lords.
Lord,
Same stage.
Yes, same stage.
Same stage.
my lord, let
We'll
this.
finally dispose of.
Please, my lord, the
Enjoy-
interim order dated 23/5/2024 may be extended till next date of hearing.
Who says no?
Please, my lord.
Yeah, we live already operating in the
Date, no?
appeal shall continue to operate till the next.
Huh?
So we'll dispose of it.
18th. Lord. 18th.
Has reached
That
up to
is,
Supreme
that
Court.
is nothing to
Supreme-
do with my case.
Supreme
I
Court
have
has
sought
upheld
for
the-
declaration to declare that it is lapsed by virtue of section 24(2). That is different.
Supreme Court
That
has
is different and this is different.
has upheld
I
the
can
acquisition.
demonstrate.
Supreme Court has upheld the acquisition, and one more important fact.
That is part of your reply.
Yes, my lord, that is part of my reply.
That fact is stated in the reply.
Yes, yes.
Same notification up.
Yes, same notification. And one more important fact, my lords. Now in this, this third respondent society has formed layout, allotted sites to allottees. In favor of one of the allottees, this very petitioner goes and executes a confirmation deed.
Oh.
This very
For
petitioner.
his client,
that-
I am not, I am admitting that.
that-
I am admitting that.
If that
I am
is
admitting
yes,
that.
How, yes, yes, stop. How can he challenge the acquisition?
How is?
Title is now, see,
Okay.
I have taken 70 lakhs consideration amount. Title is transferred by virtue of payment of consideration.
My lords, now after indoor development
All
case, my lords.
You reserve your energy.
After indoor development, my lords, either award or possession, both should be there for them to challenge the acquisition. Now award, consent award is
The
there.
learned single judge said
And
it
possession
is,
is also.
award is not passed in accordance with law. That means no award. Possession is not taken, no panchanama. Now let the commissioner be appointed to look at, see and report about the existence of the property in question.
The other side said that same notification, same about.
Same notification.
Not notification.
Went
That
up to
is,
Supreme Court.
that is not that is not the point under which.
Adjacent lands.
No, that is not proper submission. See, in the writ petition which I have filed, I have sought for declaration to declare that these acquisition proceedings have been lapsed.
Once upon a time, I told you, Mr. Counsel, that you need
Yes,
not, you
I-
you are
I
not,
know.
you are not needed, Mike. So the consent award was also before the Supreme Court?
No.
No,
No.
no.
That is.
I have to be fair.
We'll
But-
consider.
but
we'll consider.
The
Please.
learned, my lord, the learned
Please.
single judge, has proceeded on the premise, on the ground, my lords, the petition is hit by delay and latches. Therefore, there is no need to go into these issues.
I
On
I
the
can
ground of
demonstrate
delay
how
and latches
the,
itself,
how
petition
that
is not
order is
taking.
not correct by demonstrating how.
We will have to show that 50,000 was received by the mother.
Yes, there is a document.
There is a document.
There is a document. It has gone into account.
That document cannot be considered because that is paid prior to the initiation of acquisition proceedings.
What
That's
if-
what the Supreme Court has
Because
said.
in respect of this very same land, she has received 50,000. There is a document. They cannot dispute the document.
I can place all those materials. Much appreciated.
18.
Regarding in the
Non-filing
same
of-
stage, my lord, so that it reaches. That is my only anxious request, my lord.
It will reach. Why? Every matter reach.
Non-filing in contempt matters, seal number 30, Mr. S.B. Mukanapa.
Respondent accused me. Well, I request your lordship to grant 2 weeks time to file complaints report. My lords, I am preparing for the accused responding. Kindly grant 2 weeks time to file a complaints report.
What is to be complied? Representation to be decided.
Yes. 2 weeks. time.
We'll not grant 2 weeks. We'll grant some time. 10th of, almost 2 weeks.
Much.
10th of July.
Much.
Maybe, kindly date may be fixed. Seal number 31, Mr. Devraj case.
On 21st February, your lordship issued notice on the contempt for violation of the order passed in November 2023 not to put up construction on the eastern side. Now, my lord, every day the construction is going on. My lord, may I draw your lordship's attention to see the utter contempt, continuous contempt committed by the respondent. Page 59 may kindly be seen. My lord, the petitioner, my lord, is a religious institution, my lord, which challenged the construction by the 59.
Lords, I request for a week's time to seek necessary instructions and file my reply, my lords. Now there.
The grievances
Blood
that
may
respect
make-
the order passed by learned single judge, the construction activity is continuously underway. Full stop. Responding to this, learned counsel for the respondent seeks time to take instructions, put upon 8th of July.
Number 32, Mr. Padmanabhar.
Petitioner. Has been filed in this matter. Complaint. Writ appeal has been.
Violation is complied with.
No, my lord.
Not
complied.
Direction is page 20, my lord.
Page 20, yes.
Yes, my lord.
What is the direction? Last paragraph?
My lord,
Repetition is allowed. Orders of approval grant in respect of petitioners using salary grant, post, directed to approve the report immediately. Yes,
You filed a writ appeal in this matter.
where is it?
748 of 2024. We tagged along 748 of 2024.
To be listed with writ appeal
Writ
number
appeal is
748 of 24
24.
after initiation of
on 8th of
contempt
July.
proceedings.
On 8th of July.
8th of July.
Number 33. CN Nanja Reddy.
Here for the complainant.
In this matter, what is the filing rate?
In this case, sir, the case of the complainant for promotion to the post of deputy superintendent of police was not considered. But at page 28, you lost my kindly say. Annexure C, page 26.
What happened? This endorsement has been issued, DPC was conducted, your lordship. Even in the DPC, his seniority did not reach. At that time, whatever the seniority list was there,
Then file the complaints.
I filed a complaint affidavit along with the endorsement issued.
Well, I received this, my lordship may have it next week, I'll verify and I will verify and submit. Now, just now you have given
Served the copy.
endorsement. Given.
So very nice endorsement is passed, discussing what is promotion, the rule of.
No, that's not correct.
So any of the nice endorsement passed.
No, you lost my kindly see, the para 6 of annexure,
What is to be verified?
annexure C. I'll verify and submit next week.
What is it?
Two endorsements I have given.
Learned additional government advocate, Mr. Shafar Shah files and compliance affidavit producing the endorsement, which reflects that the representation of the petitioner was considered pursuant to the directions of learned single judge, which is dismissed on merits. Full stop. In that view, nothing survives.
No, Miller, that's not correct. Miller. You lost my kindly
You can
see.
challenge it independently.
No, I just point out lost. It is not in consonance with the orders passed by this honorable tribunal. I'm sorry, this honorable court. Miller. Para 6 you lost just for a while. You lost my kindly see. Page 28.
Page 28.
28, Miller.
What is 28?
Para 6 of the order of this honorable court, division bench order of this honorable court.
What is 28?
Para 6, you lost me. It is pointed out that, you lost me, got that. It is pointed out that the Department Promotion Committee has conducted its proceedings on various dates, including on 8/1/2020. And as on such date, there were no articles of charges issued as against the petitioner. And if that were to be so,
So
the
which order is sought to be?
annexure similar, the division bench order, this on the court. Page 28.
No, this is the order.
Para 6, Miller.
Which is the order? That's good. Page 20 is review. Correct.
As of that date, my case should have been considered. Only there were 9 posts are vacant and only 8 posts have been filled up. My case ought to have been considered. That is the.
It is all on merits.
Millard, on the facts, even
Monday at 2:30.
Bless.
Write down the learned so and so, the government advocate files compliance affidavit showing that the direction about deciding representation for promotion to the complainant is decided. As per the endorsement produced, full stop, learned advocate for the complainant, 6 time to verify and take instructions. Stand over to 1st of July to be listed at 2:30.
Bless.
Number 34. The GS Venkat Subbarao.
For the respondents, my lords, we had to file our objections on against an interim order of status quo in a MFA. It's an interim order of status quo passed in a miscellaneous first appeal, my lords. I have a remedy of 39(2)A if they feel that I have violated. I am the plaintiff suit. Against an injunction granted in my favor, they have come in an MFA.
So we'll say any of the remedy, any of the remedy available under order 39. Any of the remedy available to the complainant under order 39, 2 capital A of the Code of Civil Procedure 1908. From a learned senior advocate, Mr. Nindra, assisted by learned so and so, fairly stated that the complainant would opt to have recourse to the said remedy. Full stop. The complainant is permitted. The present contempt proceedings are disposed of accordingly without expressing any opinion on it. You are not for complainant.
No, I am the respondent.
So who is for the
Complainant is, we are saying, my lords, there is an order, they say status quo order is violated.
You are complainant.
Yes, madam.
So, yes.
I'm sorry, I thought.
Who makes a good argument we record? Yes, madam, what is to be done? Your remedy,
My lord.
your remedy before the same court,
I have
under
to
Code
take
of
the
Civil.
instructions from a senior, my lord.
Senior is a, senior is
not
appearing.
here. Senior will do the argument.
Oh, what is?
Senior. she
Senior,
wants us.
all right. We will keep it on.
I'm sorry, I thought, my lords, it was
11th of July.
Number 35. So Virupakshi appear.
Matter, your lordship.
Appear for the petitioners, madam.
This one humble submission, your lordship.
Right.
The complainants who have filed, some of them have passed away. The award has been prepared. The only difficulty that we are finding is that we have to bring the LRs of the deceased claimants.
My lords,
Weeks
may-
time may be granted, we will
2
identify.
weeks.
Please. Before the respond authority, my lords, I will have to make an application to bring on record LR.
Whatever you
He has
want.
to
2
bring
weeks.
it.
Great.
2 weeks when it will go to 15th of July.
Pledge.
Number 36. Shekhar.
Complaint, my lord. The accused, my lord, now provided light work for some period and sought clarification from the medical board.
Well, the direction by the learned single judge was to provide him light duty, my lord, pending, my lord, the decision by the medical board. Medical board has opined, my lord, now that he has to be given light duty, but it is not in accordance with the direction issued by the learned single judge, the medical certificate. We have provided him light duty, my lord, and the corporation itself has sought for clarification from the medical board, my lord. Therefore, in view of the fact that the light duty is provided, my lord, a memo is being filed, my lord, by the complainant, withdrawing the proceedings. My lord.
So what is to be done?
My lord,
What is to be done?
I think memo is served, my lord, by the withdrawing the proceedings, my lord.
Time being, my lord, they are providing light work, my lord, and sought clarification from the medical board.
Memo could.
So what is the direction to be complied with?
They permitted to withdraw the complaint and the liberty to revive the.
In this contempt petition, what are the directions which are required to be complete? Take decision in 4 weeks. Disability certificate. So what has happened? Disability certificate shall be obtained. It is obtained?
Yes.
It's obtained, my lord.
Obtained and
And
produced.
it is not in accordance with the requirement at page number 14 and 15. Kindly see, my lord, page 14. From page 13, my lord, the norms to be extracted in the medical certificate is listed in para 3, my lord. From para 3 to, it runs from page 13 to 15. Now the medical certificate that is furnished, my lord, has not answered all the requirements, my lord. Notwithstanding that, my lord, we have provided him light duty, and the corporation itself has written to the medical board, my lord, to clarify the points which is not answered by the medical board. But at present, my lord, the direction at para 5, my lord, has been complied, my lord, and he's been continued light duty.
So no contempt. Yes, your
Memo file, my lord.
learned advocate for the complainant files memo dated 27/6/24, which reads as under. The contempt proceedings, the memo is taken on record. Paragraph, the contempt proceedings are disposed of in terms of memo with liberty to the complainant to revive the contempt proceedings in accordance with law. Disposed of accordingly.
Ready notice, madam. Number 37.
Which one?
37.
What is it about? You want time? It was heard earlier.
This is the second petition on the same cause of action. Second petition on the same cause of action. Case number 226, kindly.
226.
26.
While reading, I thought that this is 226.
Earlier, this petitioner, filed a petition before
Oh,
the honorable court.
Then withdrawn. And my lord, subsequent to that, my lord, there are other proceedings before the
226.
271 is the
Two,
second para.
271.
271 para 5. It starts from 266.
Yes.
Now the prayer is to consider the very same application.
Prayer is to consider.
permitted to read, my
The
lord.
present petition, prayer is
Because,
to
my lord,
consider the very
my
same.
learned friend is seriously having objection, he has not filed objection. Apart from that, kindly see para 6.
No, no,
Five.
let us understand what the council is saying. Will not proceed.
Please, please.
That in the previous petition, he has challenged this 23/3/2020.
Now again he is challenging. The decision is,
Now, again, he sought mandamus to consider this very application.
therefore he wants 16th of July.
Please.
Number 38. Shaditya Narayan.
Lords, I appear for the petition. Lords, on the last date, the state had taken time to file objection.
Lords, 38, my lords. Lords, they had claimed, my lords, that it is covered by the earlier judgment in 308, but there is a distinction, my lords, that it's not covered by. So state wanted to place its objections on record. 2 more days time, my lords, will place it on record.
Lords, may I only make one?
23rd July.
Please.
Lords, may I request for, Lords, may I make one submission? Lords, there is a demand on me, which I am required to satisfy every quarter by paying 9 crores. Lords, now the next amount installment is due in July, my lords. Would your lordships have it after a week? Because otherwise, my lords, every after next week, my lords, because otherwise I'll have to pay another 9 crores pursuant to this impugned demand which is challenged before your lordships.
My
I
lords have
don't
already
have, my
passed an
lords.
order that any payment that is made will be subject.
16th of July.
But could it be in the first week of July? Because otherwise, my lords, they will stop my operations of my lease. Lords,
First
in
week.
fact, your lordships will recollect, my lords, Mr. Holla was leading me in the matter I had mentioned last time. In a similar case, the state waived the demand. Would, my lords, would your lordships consider, my lords, allowing us to go back? Because this demand is issued without hearing me.
It
When
is
you
not,
will file
it
the-
is, my lords, 2 days time is enough.
2 days,
2 days.
10th of July.
Lords,
Please.
can it be in the 4th or 5th? Because by the 5th, I'm required to pay, my lords. That's the difficulty, my lords. I've already paid 27 crores. Totally, my lords, every quarter I have to pay 9 crores.
Everybody is houseful.
I'm sorry. I think, my lords, it's a short point, my lords, whether it's covered or not. My lords, I kindly consider, my lords, it's a huge impact on me because I've invested 100 crores in the lease. Now, my lords, they don't give the forest clearance and say, sorry, without paying the demand, you can't operate.
So there is no bargain in merit and dates.
Lords, lordships kindly have it in the first week, my lord, so that your lordships may consider my circumstance before I have to pay again, my lords.
Sorry. 10th.
Grateful.
Number 39, HR Shourie.
The public interest petition,
39.
the contention, my lord, is that a Gunda Topu, my lord, which is a round cluster of trees and an ancient water source in a temple, Kalyani, my lord, it's called the Kalyani in Kannada language. It's, my lord, a tank. That land has been allotted, my lord, and given to the BBMP for a Muslim burial ground. My lord, I've raised number of contentions, my lord. Notices have issued,
Notice
no
was issued.
counter is filed. So, my lord, I request that some interim order may be necessary. The reason is this, my lord. Today, as of today, my lord, no burial has taken place there. The trees are there. Your lordships may see, my lord, in the vicinity of the same place, my lord, in 2 to 3 kilometers, there are 6 Muslim burial grounds have produced all the RTCs. And an application is filed, no public notice is given.
At least we grant 3-4 days time to file, then we'll consider.
Your lordships, I
Lord,
appear for
let no
responding.
burial take place, my lord. That urgency of burial was in COVID, my lord. Today there is no such urgency. Let nor be burial take place, my lord. It's a Kalyani, my lord, a holy place.
Your
When you will
lords-
file?
Your lordships, I appear for respondent number 4. I've recently filed my wakalat, your lordships. I'll file my response seeking for a short adjournment. Your
Lord,
lord-
BPMP, my lord, has nothing
There
to
keep
say.
it on 3rd of,
Please, your lordships.
file your response before that.
Please, your lordships.
Lord, BBMP is only the grantee, my lord. They have nothing to say. I am challenging the grant by the deputy commissioner.
So who has granted this land?
Deputy commissioner.
But if I may make a submission, I'm not a party in this, but it's on my application, this grant has been done. I'm at page 107, they produce a copy, but I've not been made a party. If they can make us a party,
Nobody will invite you unless you yourself.
because they have produced our application at page 107.
My lord, my grievance is against the deputy commissioner. Complete violation of land grant rules, act, no inquiry. They asked for 1 acre, 26 guntas, where there is the revenue record shows it is a Gundu Topu, which is, my lord, a clump of trees, and there is a holy Kalyani, which is being used by the community there. Kindly, my lord, see para 16 of the writ petition. I've given details. I've filed all the RTCs. Page 18, para 16. These are the Muslim burial grounds in the vicinity. 30 guntas, 4.5 kilometers away. Then 2 acre, 20 guntas, 5 kilometers away. Then another 25 guntas, 5 kilometers away. If an application is submitted, my lord, the least that the deputy commissioner can do is to find out, my lord, under the land grant
But
rules.
that other community has no burial ground. That is what,
No, all these are Muslim burial grounds.
which,
These, my lord, page 18, page 18, para 16 onwards. I produce RTCs.
we'll consider next day.
My lord, this order is appealable under section 49C. My lord, my learned friends can go before the DC, my lord, put forth all these contentions, and then an order will be passed. Their
An order-
contention is that no inquiry, they haven't been heard. My lord, even the mosque can go before the Deputy Commissioner, my lord may fix some time. My lord, 4 weeks to see that this is
That
disposed of.
somebody's instance, one of the communities permitted to bury the
My
body
lord, we don't
in
know.
the burial place of the other community. It
But
appears.
No,
that
this
is-
was
that
not a
is the
burial place, my lord.
intention.
What was granted was a clump of trees. Gundu Thopu means it's a big, my lord, clump of number of trees are there. And there is an ancient Kalyani. Kalyani, my lord, is that old stone structure wherein along to Hindu temples, my lord, they have this water tank where they have ablutions and other things. So in the tank is there. The report shows that there is a tank there. Kalyani is there. No inquiry, nothing is done.
It's
The
precisely
least
for
that they
this
have to
reason.
do under the rules, my lord, is the deputy commissioner is supposed to make out a list.
We'll find out something. Let us. Who, you are for whom?
I appear for BBMP, your lordships, R4.
And who has given?
BBMP, the deputy commissioner has given this land
Who
to
appear
be.
for deputy?
Yeah.
I appear for the deputy commissioner.
File your reply
Where you?
on or before 3rd.
My lord, that's too short a time, not that.
Then till then, no burial should take place because it's a holy place. If they do burial,
My
then,
lord-
my lord, if I succeed in the writ petition, my lord, they'll have to be exhumed bodies. Annexure Q. This is the English translation. At 226, my lord. The president, second line, my lord. Masjid so-and-so has requested for grant of Gundu Topu government land in survey number 369 of Beguru village, measuring 1 acre 26 guntas for the purpose of Kabristan to the people of their community. Accordingly, proposal has been prepared. Proposed land in survey number 369 as per Akar Band measures 1 acre 26 guntas. Entire extent is C Karab. As per Kannada copy, the said land is Gundu Topu. It has 11 old trees, 1 Kalyani. As per the sketch prepared by the surveyor, it is vacant land. Farmers have not submitted any application for grant of land in form number so-and-so. No pending cases. Land is not acquired for any purpose. As per checklist and Darkhast memorandum, said land has been proposed for not to grant any organization. Report submitted along with surveyor sketch. Mahazar is prepared with the villagers. Grant for Muslim. This is all consideration. The rules require that he must prepare a list of lands available for grant under the land grant rules. There must be a public notice. This is public property. And the Hindus are having a right over that land. And the speed at which all this happens, my lord, is somewhat amazing. 4/6/21 request comes. Tahsildar acts on 22/6. All reports come in the next couple of months. No public notice.
My lord, order is 11/9/2023. Nothing has happened. My lord may grant me some time, my lord. I'll place the facts before my lord.
Today, the status quo is that land is as it is, my lord. I don't want, my lord, somebody to be buried there because your lordship knows it'll become very sensitive. What will happen, my lord, is if they now start a burial, then the position will change. So today, my lord, whatever position is, let that not be altered. That's all I'm requesting.
Let them, we'll wait for the reply.
Yes, my lord, I'll place all the.
Because initially, nothing is granted. Initially.
No, your lordships have pleased to issue notice, my lord, on the last occasion after hearing.
Four.
That's why, my lord, it has come. And now, my lord, they have not
Lord,
chosen to
because of
come and
the
say
elections,
anything.
I was not able to get instructions, my lord. Now I will get instructions. Considering this is of importance, my lord may grant me some time.
Important,
But-
not in the sense of, but there are cases that there are other burial grounds for the same.
No, my lord, that is what, my lord, I'll get that verified because if
Full
there are
details,
six.
my lord. I've given RTCs, extracts which show the name that this is a Muslim burial ground. I produce all the documents, my lord, C1 onwards.
You
If-
find out. 3rd. Third, we'll consider on that.
Some interim relief, my lord.
On
Let
that-
them not bury, my lord. Please see, my lord, it'll become very sensitive, my lord.
Let them
That's,
not bury.
Lord, I don't
bury
understand the
means the
government's
bodies have
anxiety
to
in
be-
this case, my lord.
They have to seek for, my lord, burial at that place.
Let them not carry any burial, my lord.
Take instruction on Monday. Even if you don't file reply, take instructions. What is the position?
Yes. You'll have to file an application for impeding. See, the mosque, they take permission from the mosque.
Number 40. To Ganpati Bhatt.
The notice has been issued in this case. Connected. ಅದು ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದ ಡೇಟ್ ಯಾವುದು ಅದು? ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದ ನಂಬರ್ 10th ಹೋಗಿದೆಯಲ್ಲ ಅದು ಯಾವುದು? Annexure J has been challenged, but yesterday your lordship issued notice and posted on 10th July.
No,
And
no.
this is connected matter.
No, no, Lord, yesterday's matter is ordered to be tagged along with this matter.
This.
It is going on like this.
So then both can make.
It is, I'll give number because
Because in this matter, there was an order, previous order saying that the revision is availability of revision is kept open.
this is kindly see, my lord.
That may kindly peruse the order
Page
dated.
number 1.
10th we'll take.
10th, please.
10th.
Connect along with 10180.
In that there must be same order.
Please, my lord.
In that matter, the same order will be there.
Yes, my lord. Definitely, there is no issue. There is no order.
To be listed with
10180 of 2024. For issuing directions to the payment of stamp duty revision that he is saying. We have challenged the notice. 10.
Number 41.
Whatever.
Gangi Reddy BV. Number 41.
My lord, this may be called on 3rd of July, my lord. It pertains to section 5, the Karnataka scheduled caste and scheduled tribes.
That is kept on which date?
3rd, my lord.
Third. Notice returnable on third.
Obliged.
Already issued. Third.
My lord, on submission, there is an interim order, my lord, to be kind extended.
Interim order is there?
Yes.
Interim order already operating shall continue till the next day.
Thoroughly.
Till
Next.
till further orders.
Yes.
Since we are hearing on third.
Number 42. To Srinivas Rao CN.
On the last occasion, my lords directed the expert committee report was placed on record and then my lords directed copy to be given. It has been given.
We have also not received copy, my lord.
Copy of the report. It has come on us now.
There's an order, my lord, on 1st April 2024, my lord. The expert committee was directed.
My lord, the issue arises like this. The provisional key answers were published. Against that, objections were filed. Then what is final key answers were published. Within 1 week thereafter, they published a provisional select list. About 900 objections were received against the provisional select list, which contained inter alia that the final key answer itself was wrong. Then my lord, the examining authority referred the matter to expert committee. On the basis of expert committee report, the final key answers were redone. That was questioned, my lords, before the learned single judge. And learned single judge holds that the error could not have been corrected. My lords, nobody has got a vested right to be selected or appointed on the basis of a wrong key answer. That is the short question, my lords, in this.
224.
Key answers.
Key answers, my lords. In fact, my lords, on an earlier occasion said, what could be the objection against the expert committee report?
So your report is submitted?
Yeah, it has been submitted and.
Second respondent, my lord, is the examination authority. They made a submission that there is a report, my lord. The order on the honorable court is that they must furnish copies to all counsel. I'm told my learned friend has had the benefit of it. I have not had the benefit of it, my lord. They may give me a copy. And the matter will have to be heard, my lord. Another thing is, many respondents I notice are not served, my lord, in the connected case. So, illa. Appellants, my lord, may please take notice, my lord. In 42.6, I find from the cause list, all respondents are not served.
Who are not?
In serial number 42.6.
Let fresh notice go, and in the meantime, you get the report.
Yes, my lord. So far as I am concerned, if they give me the report, I am ready to argue.
I am ready, my lord, sir.
Unserved respondents.
Report has been given.
Can have alone. We'll keep any urgency. 22nd.
Urgency is this, my lords, because persons, about 400 persons.
No time, but 22nd July.
My lord, they have been appointed and we are 105 people.
In the meantime, the copy of the expert committee report shall be made available to all the parties.
We were more meritorious in the list because of the order of the single judge. Even though we are more meritorious, we have not been appointed. That is the urgency.
But if it could be had on a shorter date, my lord, because there are several students who are affected by your lordship's order pursuant to an order in this writ appeal.
We give shorter date, it will not be possible to hear the matter. We can give shorter date.
We'll
not
take our
every-
chances, my lords. We'll take our chances. my lord.
You take a chance tomorrow.
Grateful.
Next. Not possible to hear every matter.
Copy.
Be reasonable.
There is no.
18th.
Grateful.
Or safe, take chance on 16th.
Great.
Will be 1 day later, my lord. 1 day later.
Monday.
16th, on particular 16th, I have some engagement outside.
15th.
15th or 17th? 17th, if I'm-
17th is holiday.
18th then.
18th then.
18th.
Number 43. Unni Krishnan M.
Lord, this covered by your lordship's judgment on pay revision. Lord, the very basis of the impugned order is that other order which your lordships have set aside. So, yes, my lord, I mean, this is.
My lord,
Yes.
I have filed my response, whereas maybe the similar question of 1997 pay revision, maybe this honorable court might have
This is which 97, same period.
Same, my lord, the same company,
My lord,
similar
but
employee.
I have placed certain documents which were not placed before the previous writ appeal, my lord. That may be considered. I have filed my response along with the documents, my lord.
First, I'll review in that petition. Then produce the document.
True, my lord, my learned friend is attempting to produce documents which are not produced before the single judge.
Writ petition also, those documents have been brought, my lord.
We'll just go through and then decide, then pass the order.
My lord, two minutes,
Tuesday.
5 minutes time may be given, my lord, to bring before these facts, my lord. In fact,
Tuesday, time is given up to Tuesday,
for here,
2nd of July.
please.
I'm grateful. Lord, the other judgment we have filed along with a memo, my lord. It is placed.
My lord, I may be permitted to file the compilation of judgments, my lord.
Anything?
Number 44, 45 are urgent. Number 46. Tarun Govindraj.
My lord, I'm appearing for the complainant wife, the mother, complainant mother in this matter. Lord, the marriage between the parties was dissolved by judgment and decree dated 5th of December 2020. If I may take my lords through the terms. My lord will find the same at page number 23.
So this is what? Contempt.
This is contempt.
Page?
Page 23, if I may take my lord through the terms of the divorce decree. Points 4, 5, and 6, my lord. The first petitioner father, who is the accused before the court, undertakes that he will take the responsibility of being the custodian parent of their minor son. While their minor son will continue his education in the United Kingdom under the care and custody of the first petitioner father, the second petitioner mother shall have the visitation rights. At the convenience of all parties, regular video calls between the second petitioner mother and the minor son shall be arranged. The first petitioner father undertakes that arrangements will be made solely by him to have the minor son visit the second petitioner mother during the minor son's annual holidays at least once a year. During the minor son's stay in India, he will be under the care and guidance of the second petitioner mother only. My lord, these are the terms. I have visitation and interim custody as per this. For a year post this, in Jan 2021, the son was taken to the United Kingdom as per the terms agreed. Until Jan 2022, I had video call access. Subsequently, since there was the COVID lockdown, they could not visit India, and hence I did not request for the same at that time. But post Jan 2022, I have had no video calls at all with my minor son, despite several emails being sent. In fact, I had received a notice from the accused, which Your Honor will find at page number 28. He justifies it saying that he is married to someone else now and she has a daughter, and hence there is emotional turbulence which my son is facing, and hence he does not wish to provide any access.
What is the contempt? But tell us.
The contempt is that I'm having no access to my child at all. I have initiated proceedings for execution even before the family court.
I beg to submit, my lord, that there has been no contempt here. The order that my learned colleague refers to also has a specific recital that also there are an agreement of the same, that is both the parties, as they believe. Page 23, the order.
Page 23.
23.
Yes.
Which is the order which they are now holding us to be in contempt of. It says, both the parties petitioners do not have any objection to the above arrangements. Also, they are in agreement of the same, as they believe that this is in the best interest of their minor son. However, at every step, input from the minor son will be considered and given effect to by the father and mother. This is the terms of the order. And for even according to the counsel for the petitioner, for one whole year, there has been a systematic video call between not the mother, but the grandparents, maternal grandparents. And occasionally the maternal grandparents used to add on their daughter, that is the mother of the child, on the call. And even in our notice, we have acknowledged the love and care that the grandparents, maternal grandparents, have showered on the child.
Have you filed your reply?
I have.
Okay.
I submit there has been some
The
rectification.
child is with
The child is in the UK, very comfortably settled in with his father and his stepmother. And the picture that I have put shows how very pleasantly the child has been handed over by the mother and her parents to the father and his wife and stepchild.
Video conference is held?
There has been, yes, video
No,
conference.
no video calls are being held, man. I beg to submit. I have no video call access at all. The last video call I had was on 19th of February 2023, that too with the intervention of the family court, after which it has not been followed. If I may take my lord through at page number 48 of the contempt petition, my lord.
It's only after the turbulence started that we have denied.
Paragraph 5 is complied with or not? Regular.
The video call access was complied for one whole year. Thereafter, there was turbulence because they were trying to alienate and disturb his settling in comfortably with his stepmother. At that point, we sent out this.
Now, when you are ready to have a video call with father?
The video call was ordered by the Honorable Family Court, and after which the mother and child had the video call and the child refused to get on there.
All right. Now, when will we?
We are willing to have the child have a video call even in this court, Your Honor. Your Honor can ascertain the child's intention because the parties have agreed that
Arrange one video call with others.
Your Honor may suggest a date and we'll have a.
Yes, Mr.
Lord, video calls as well. And also there's a term which directs that the child is to be brought to India at
You
least
are
once a
interested
year.
in having a video talk
Certainly.
with your,
To start off with, certainly, my lord. But the order to be followed in letter and spirit, and hence I'm before the honorable
are
court.
you willing and ready to have a
I am,
video talk?
I am
with
willing
your-
and ready. I am willing and ready.
Willing?
Willing.
So on which date?
I'm
Contempt is-
ready even today, tomorrow, any date.
Non-compliance is alleged in respect of order dated so and so, 15/12/2020. 15/12, no,
5/12, my lord. 5/12/20.
5/12/2020, which inter alia contains the direction that at the convenience of the parties, regular video calls between second petitioner mother and the minor son shall be arranged. So child is at UK.
Child is in the UK
So we-
attending school in the UK.
Video call to be arranged with whom?
Video call can, Your Honor may ascertain the mind of the child because even the order stipulates
Child is with father.
with the father in the UK. He's attending school there.
What is the age of the child?
The child is now 7.
7.
Yes. And there had been a video call at the instance of the Honorable Family Court.
You are
and
for whom?
I'm for the father of the child.
Father.
Yes, who is now the contempt. Because there is a particular recital in that order.
Mother is where? Bangalore.
Mother is in Bangalore.
Mother is
She
in
left the
Bangalore.
father, the documents I've submitted will show that she left the father and child because she went after.
Child aged 7 years old is in custody of the father as permitted by the court and has
As agreed between parties.
been engaged in the education and has been staying and has been residing in England, taking education there. Full stop. In course of the hearing today, learned advocate Mr. So and so for the complainant wished that a video call may be arranged to enable the mother to talk to her son. Full stop. The other side has no objection. On which date, Mr.?
It may be taken up tomorrow, my lord, the video call.
The parties shall arrange such video call within 1 week at the mutually convenient time. Full stop. Put up.
Please.
Let us see, put up on 23rd July.
Much obliged.
Number 47.
Yeah.
Wait for the complainant in a matter.
My lord, the complainant is an association, apartment association, which is not registered.
Where
Mo-
is the, where is the certificate of Mr.?
My lord,
Where is the certificate whereby he can address the court? Under the rules. Is there, then yes, otherwise. no. This is 47. लिखा है Home says it. Oh, let's see. So what is the contempt?
Milord's contempt is for non-compliance of order passed by the learned single judge in WP 13059, which can be found at page number 118, Milords.
Investigation.
No, Milords. What has happened is it pertains to the private complaint for SC/ST Atrocity Act that was instituted by the party in person, the respondent here in Milord. The said petition, the complaints were quashed, and a cost of 25,000 was imposed on that on the accused respondent here in Milords. The same has not been deposited despite repeated reminders, despite repeated requests. The Honorable Supreme Court has also confirmed this particular order of the learned single judge. In Annexure B, Milords, which can be found at page number 119.
What is the contempt?
My lords, the contempt here is that the amount as has been directed by the learned single judge, my lords, has not been paid by the accused herein, my lords. Despite repeated requests.
25,000.
Yes, my lords.
And then Supreme Court imposed
Further cost also, my lords.
of 30,000
For 30,000. Yes, my lords.
on the party in person.
Yes, my lords.
Yes, when you are going.
My lord, the complainant is a association, apartment association, and it has not been registered in the first place. The deed of declaration, which was registered with the sub-registrar Kengeri, has been fraudulently registered. Therefore, my lord, I have filed a memo wherein this honorable court has passed a circular dated 26/5/2022, wherein if at all the petitioner, if an association or a company or a partnership concern or a society is a complainant, then it has to be verified whether it is a registered association or not.
Learned advocate, Mr.
Raghava Parthasarathi. It's Raghava Parthasarathi.
What is the name?
Raghava P.
Serial number? 47. Raghava P. For the complainant points out that the following direction regarding payment of cost in judgment and order of law in a single judge dated 12th September 22 is not complied with. Then quote this V5. So only this cost part.
Indeed.
Part.
Yes,
full
ma'am.
stop. He further points out that your K.S. Ravi Kumar,
Yes.
respondent K.S. Ravi Kumar, who appears as party in person, approached the Supreme Court by SLP number 340.
My lord, the Supreme Court did not interfere in the order judgment, but
You don't interfere now when we are dictating. Special leave petition number 40397 of 2022 against the aforementioned order of judgment and order of law in a single judge, which contained the above direction of payment of cost. Full stop, paragraph. The Supreme Court passed the following order. Quote the entire order at page 119. It is this flap, green flap. It could be seen that the Supreme Court has further imposed cost of 30,000 while confirming the judgment and order of law in a single judge. Full stop. Learned advocate for the complainant therefore rightly submits that the respondent party in person is liable under the orders of the court confirmed by the Supreme Court to pay the total cost of his 55,000. Full stop. When you will pay?
my lord, this is only regarding 25,000. The Supreme Court.
Supreme Court has imposed the 30,000 to be paid to the
Which-
Supreme Court Welfare Association.
That you have paid?
No,
Not paid.
No.
Full stop.
my lord, I filed a memo.
It was given out that even the cost imposed by the Supreme Court to be paid to the Supreme Court Employees Mutual Fund has not been paid by the party in person, be that as may, full stop. The judgment and order of law in a single judge insofar as relates to direction to pay the cost of 25,000 has to be complied with, full stop. When the party in person paragraph was asked about the time within which he would comply with the direction by paying the cost, he sought to raise the contentions on merits, which cannot be considered at this stage when the court is exercising the contempt jurisdiction.
My lord, I'll submit my complete full-fledged objections to the.
So time is granted to pay the cost to the party in person with little leniency, since it is party in person who is appearing. Full stop, unless within 2 months from today, the amount is not deposited, the lot will take its own course. 2 months is not necessary.
My lord,
25,000, 1
The
month.
complainant has no,
Next,
my lord,
whatever.
complainant has no locus standi to file this case in the
That we
first.
are not concerned, Mr. Vazin. If you don't know the procedure of court, then come through advocate. Don't waste time like this.
My lord, I'll file my full-fledged objection.
On 27th of August.
My lord, I'll file my full-fledged objection.
You file. This is our order. You can file. 14% is not precluded from filing the.
He's a practicing advocate as
Yes,
well,
yes.
Millets.
He's a practicing.
Yes, Millets.
Serial number 51, list number 1. Record council or not well. It's held down or signing the state. Number 51. 25th of July. This is the 25th, 51. I represent, my lord, the hospital, my lord, is one of the respondents. There is an interim order operating, my lord, in serial number 51. What is the matter? Lord, the prayer, my lord, is for a direction that the landowners who are under whom, my lord, I have taken a lease, they have to produce all the documents before this honorable court. And there is an allegation that the corporation has not collected taxes from my, my lord, landowners. It is PIL. It's a PIL, my lord. That's the contours of, my lord, the prayer that has been sought. There was an interim order, my lord, which has been modified, and earlier is, that is the earlier. No, I will. Good.
I didn't put this instruction and.
Still number 4, Mr. Mohammed Tahir. Still number 4.
Notice. 5th of October. Issue.
Similar pattern, brother. Maybe tag along with
5th of August.
5th of August. List number 2. Serial number 1 for withdrawal of writ petition. The Suraj Nayak. Here for the petition.
Memo is filed. Memo dated 22/6/24 is filed seeking withdrawal of the petition, full stop. The memo reads as under the court the memo, view of the above, dismissed as withdrawn. Those who file memo no leave. Those who file memo. No. Liberty is always there. Liberty is reserved if the trust to initiate the appropriate proceeding. For press cause of action.
Serial number 2.
Any subsequent development is press cause of action. For which liberty is out. Appropriate.
Respond accused. Serial number 2. Mohammed Buzazim.
matter of 31st of March, they had undertaken that they will pay the rent as per the order of the single paying shop, but they have not complied with that matter. 31st of March, because they undertook before.
And this is for, not for hearing. Office of Justice removed?
Office of Justice.
Removed. Four weeks. After 4 weeks. Yes, ma'am.
So 3 urgent, serial number 4. Mr. Clifton D. Rosario.
Appearing for the petitioner, my lord, I request a week's time to comply with the office objections in this matter, my lord.
So what do you want?
May I request a week's time to comply with the office objections, my lord?
2 weeks service is granted to comply with the.
My lord, there are 3 IAs that they have filed.
2020-23, madam.
My lord, I'll positively comply within a week, my lord.
But what we are doing for 4 years? Comply within 1 week.
Please.
1 week. The office of thing complied within 1 week, failing which the petition shall stand automatically dismissed.
Please.
Without reference or order of the court.
My lord, let them serve us a copy of the 3 IAs. There are 3 IAs in this, my lord.
filed by the petitioners.
You don't have the.
No, I don't have
The petition shall be supplied to learned.
the IAS.
Madam.
Please, my lord, I'll serve a copy.
Yes.
This, for second time, office objections, seal number 5. Mr. Bhadra Gowda. Mr. Bhadra Gowda.
Is not after 4 weeks.
Seal number
10 over to August. 12th August.
seal number 6.
Lords,
Monesh Kumar.
for 3 petitions, Lords, other appeals, Lords, notices have to be ordered. And with regard to the office objections on submission.
Little louder.
With the office objections, my lords, I have one submission. That is, please, my lords, I was the respondent before the learned single judge. There are some plans which have been produced, my lords, by the petitioners in such cases. Now, I do not have a color copy of that. I have a photocopy, my lords. I have
The plan is dispensed. Rest of the offices will be.
My lord.
Will be complied with within 2 weeks.
My lords, in other matters, I'll hand over a list, my lords. Notices will have to go, please, my lords. I'll take steps.
I please seek permission to submit with regard to 6.7, my lord.
Number 7. For third time, office objections.
I appeared for the complainant, my lords. In the last hearing, your lordship have directed the registry to list this in admissions, my lords. I have complied with the office objections. Again, they have raised office objections.
My lords, in serial number 7, I appear on behalf of the accused number 2, my lords. I seek for a week's accommodation in this matter to file my counter affidavit.
For 16th of July.
My lords, short date, my lord. Short date may be given, my lords. 3rd of
12th July.
Grateful, my lords.
God bless me.
Office objections are complied, my lords. In the admissions next.
We listed on 12th. The contempt applications will be listed on 12th July as council states that the office objections are complied.
Grateful, my lords.
For fourth time, seal number 8. Mr. A. Nagarajappa.
For 4 weeks, 12th August.
Number 9. For fifth time, Mr. Naveed Ahmad.
Lordship, regarding photographs, I had only one set of originals, which I have produced it in the first set. And the second set, the photograph is Xerox copy.
You produced color copy or not?
I don't have the color copy. I'll make it a color copy if it is necessary. The first set I have already filed. In the second set, the copy is Xerox.
So, office objections regarding photographs is dispensed with on condition that in course of the hearing, learned counsel for the petitioner shall make available to the court 2 sets of.
And regarding second objection, it is the respondent who have filed the objections. They have to comply those objections, and they have not served the copy of the objection also.
There are tables that will listed for petition for the listed hearing.
Number 10. Mr. Abhinay Vaiti. Seal number 10. 6 office.
Then 4 weeks, 12th August.
First, seal number 11 disposed. Seal number 12. Shri M. Srinivas.
2 weeks time is granted to remove your.
Number 13. Shanbag Sanjeev Rao.
2 weeks time, 4 weeks time is granted.
Office objections along with council submissions. Seal number 14. Mr. Suresh T.S.
Your Lordship, one is with respect to translation only of a particular map. Your Lordship, I brought it along with me with the memo.
Sorry,
Please, Your Lordship.
second office objection.
One office objection with respect to no translation being there with respect to a map. That map, Your Lordship, if Your Lordship permits, we'll produce it with the memo. We've brought the translation. The other is only one page where they say it's not very clear. It's of a lease deed, which is at the page 1, Your Lordship. The entire lease deed is very clear. It is only that first page, Your Lordship, even otherwise it's quite clear. That's the only office objection.
Objections regarding translation of the map is dispensed.
Please, Your Lordship. Your Lordship,
The office, what is the other one?
please, Your Lordship, the other one is clarity of a page of a lease deed, Your Lordship. Annexure E.
As far as the other office is concerned, about the readability of the page, it is provided that if necessary in the course of the hearing, counsel for the petitioner will supply the type copy.
Please, Your Lordship. Your Lordship, urgency is this. The lease for the mining, Your Lordship, for 30 years has been given to us only last year. All of a sudden, now they issue us a notice stating stop work
So
immediately.
this will come in the reply.
Please, Your Lordship.
These are the things to come in the reply.
Difficulty is for 3 months, they haven't allowed us to work. As a result, the banks are proceeding against us.
When do you want?
Your Lordship,
9th of July?
Your Lordship, any Monday, Your Lordship.
What is the urgency?
Your Lordship, urgency is that they have stopped us from doing any work in our mining area, quarrying area. And we have a lease for 30 years, taken a loan from the bank for all the material. 3 months, we have not paid our staff also, Your Lordship. Please, Your Lordship.
Number 15, Mr. B.K. Manjunath.
There are three office objections raised in this. One is regarding the color photograph. The same was produced by the respondent number 1 in the writ petition.
Within 3 weeks, the office objections shall be removed by the Next.
Lords, the second thing is with regard to the condemnation of delay.
Second is same, you are okay.
My lord, the days have been calculated from the date of dismissal of review petition.
Day of delay.
Yes, my lord, delay of 41 days. It has been calculated from the date of review petition, dismissal of review petition. Dismissal of the review petition.
Calculated from?
From the date of review petition, dismissal of review petition.
So that is wrong. It is incorrect.
My lord, the actual dates are 41.
You are for whom?
For the appellant, my lord.
So what is the appeal?
My lord, the reason is there was an election duty which was given for the appellant. Because of that reason, the delay was. Lord,
what is the challenge?
Lord, we have challenged the respondent had challenged the resolution which was passed in 2012 regarding the cancellation of Hakku Patra, the sale certificate.
8th of July.
Number 16. SP Patati.
Regarding the office objection, my lord, the office has raised the objection saying that the typed copy has to be filed, my lord. This is an annexure. J and J1 are the layout plan, my lord. So I had filed the layout
The
plan.
type copy of annexure J, J1 and M1, which are.
These are the
maps,
maps, my lord.
is dispensed with.
And annexure N is also there, my lord. Second objection is annexure N, my lord, that I had also filed the typed copy, my lord.
It is all available in the
It's available.
photocopy can be done. Submission of the council. That's much, nothing more is required.
I had already filed, my lord. And I already complied, my lord. It is there, my lord.
The rest of the objections have been complied with.
Please.
Already complied with, yes, next.
But short date, my lord. It's a serious threat of disposition, my lord. Short date.
You will listed in 10 days, all matters. The office of this cleared.
10 days. Number 17.
Yes, from 17 to 20, my lords, sir. So 17 to 20, my lords, I appear for the appellants in this case, my lords. The office has raised an objection saying that there is a delay of 300 days, when in fact the order was released only the month of November. That is the first objection. And a small portion of translation, my lords, they say I'll have to place. I don't mind placing that also on record. I'm not relying on it. Lords, these are all matters per se pertaining to transmission lines, wherein compensation there has been once again awarded when I had already paid it as per the orders of the Deputy Commissioner and the District Judge, my lords. And the amounts have also been deposited. They have filed now execution. My lords, there is an urgency. There are quite a few matters, my lords, which have been placed, my lords, which have been filed, challenging the order of the single judge.
Notice. Notice in delay application, returnable on sixth August.
Lords is granted notice, my lords. I'm obliged.
Yes.
18 to
17 to 20, my lords, sir.
Over.
List number 1, number 48. Mr. R. Padmanabh.
For complainant in this case, my lord, in this case, my lord, the order which breach is alleged in this contempt petition is disposed of by following the writ petition of by my lord annexure C, my lord. In that writ petition, my lord, some conditions are recording while disposing the writ petition, wherein, my lord, condition number 7 is violated by the accused, my lord, which I have stated in my contempt petition at para 6, my lord. They are not allowing me to run my club with lawful activities, my lord. The accused are not allowing me to run my club with lawful activities, ma'am. They are not allowing to open my club itself, my lord.
We have filed the complaint affidavit. We have filed the affidavit, your lordship.
Yes.
No, this does not survive in view of the, we have already filed the complaints affidavit in
They
this
have
matter.
filed a complaint, not
survive.
stated where I have,
Will not survive.
Yeah, does not survive. By virtue of this order, they are expanding the scope of contempt itself. They cannot deprive me of performing my policing duties.
What is the decision?
my lord, I don't have any objections to.
You show what is the decision in writ appeal number 932.
That also is produced here.
Not that, my lord. Writ petition number 3280, annexure C, my lord, 3286, my lord. Kindly see page number 21, my lord. Condition number 7, my lord. The respondents are directed not to interfere with the lawful recreational activities carried on by the members of the petitioner club association, whatever, my lord.
No, your lordship.
They are not allowing me to run my club daily, my lord. They are not allowing me to open my club, my lord. My lord, as per the order direction by this, by the learned single judge, my
Which
lord.
directions are to be complied with?
Yes.
Mr. Counsel? Which are the directions you are seeking to comply with?
My lord, my respectful submission, my lord.
Submission, we don't
kind-
want any submission. You show the directions which are here to be, you are here to comply with.
My lord, that condition has to be followed.
Which
by-
conditions?
the
Read it.
Condition number 7, my lord.
Read it. Read page 16, paragraph 2, in the division bench decision of this court. Read
Yes.
it.
Page 21, my lord.
We are asking you to read paragraph 2 of page 16.
In the division bench decision of this court in writ appeal number 932 for 1974 between A.V. Vinoda and others so and so, disposed of on 11/12 to 1974, it has been held that like cases should be treated alike, and if relief is granted to a litigant, similar relief cannot be denied to other similarly circumstanced litigants, subject to all just exceptions.
So this order is under contempt.
But this appeal is followed by the one writ petition is disposed of, my lord. Kindly see annexure C, my
So
lord.
that which are the directions you want to comply with, we will not proceed further. Which are the directions you want?
My lord, they are not stated any violations in their affidavit, my lord. I have not committed any violations, my lord.
Forget the affidavit. You want the authorities to comply with which directions?
My lord, kindly see my contempt petition para 6, my lord.
Where is that? Where are the directions? Learned advocate for the. You want to prepare yourself? Which directions you want to comply with? That is the simple question.
And my lord, they permit me to run my club, my lord. They have violated the conditions, my lord.
Which directions you want to? Unless you answer, we are not going to go.
My lord,
101%.
sometime. Have it summoned. I pray
How
for
long-
some time.
Since how long you are practicing?
I pray for some time.
Since how long you are practicing? Answer it. Why you are
10 years.
repeating?
10
10
years.
years. 10 years. So which are the directions of learned single judge which are to be complied with in this contempt proceedings? Or which are breached, not complied with? Which are the directions violated by the other side?
My lord, this learned single judge order disposed of by following the judgment, my lord, or annexure.
So
C,
where is that judgment?
Annexure C, my lord. Kindly see
Read
annexure
it.
C,
That
my
is
lord.
what we are saying.
Page 21, my lord.
Read it.
Some conditions are recorded in that.
So which condition is not
My lord,
followed?
condition number 7, my lord.
7.
The respondents are directed not to interfere with the lawful recreational activities carried on by the members of the
What is
petitioner,
your
my lord.
response? What is your response to this?
This directions in this writ petition, they have laid down certain guidelines where if there is a recreational club, that is a registered club, it is not only one condition what my learned friend is telling. See, they cannot restrict my right of policing. See, I am a law authority. I have my right, I can visit and all these things. But not only this condition, they have to.
Red matter.
No, this is a club matter, where this is a recreational club. So he has to not read only 7. If your lordship kindly see all these things.
Red and.
He has to comply with all those guidelines and then take appropriate license and run it. Because contempt does not.
The grievance.
My lord, my grievance is they are not allowing me to run my club.
No, we
They are
have
not
never-
allowing me to open my club, my lord.
See that he has to
that
go-
grievance, my grievance is at para 6 of the contempt
He
petition,
has
my
to
lord.
go before the appropriate for.
Open and start your club.
In spite of
Let him start if it is lawful club.
Then start your.
Let them undertaking may be given in their affidavit.
How can we give undertaking before this
My
court?
lord, I don't have any objections
he's
to
lawful
interfere
club,
with,
let him run
if
it.
I conduct any
Open and-
unlawful activities, my lord.
You open and run your club. If they interfere illegally or without any
Yes.
cause, then come and say that there is a violation.
Like your lordship said, if you interfere illegally.
My lord, they are not stated in their affidavit, my lord, which unlawful activities I have conducted, my lord.
But
Kindly
have
say,
you-
kindly say,
Have you started?
no, my lord, I have not started, but they are interfering with,
Following was the order passed by learned single judge on 21st September 21 in the writ petition number 17052 of 21. The court entire order, full stop. The direction was to the petition was disposed of in same terms as per the order passed in writ petition number 3286 of 2020. Full stop. The said order passed in writ petition number 3286 of 2020, paragraph dated 20th February 2020. Figures on record, into bracket annexure C, page 17. Herein, certain conditions are stipulated by the court to be observed by the authorities when they inspect or visit the club to examine the activities carried on by the club. One of the condition, paragraph number 7 reads as and page 21 of the condition, full stop. The only grievance of the petitioner is that only grievance of the complainant is that the respondents are not permitting the complainant to carry on the recreational activities at the club. Full stop. When queried whether the club is running, learned advocate was entirely at his receiving end. When the club was not running, the question of non-compliance of the above direction does not arise. The
my
present
lord,
contempt is
let them
thoroughly
allow me to
considered.
run the club, my lord, with the lawful
The
activities.
present the contempt petition is thoroughly misconceived, it is dismissed, full stop. If in future a question arises after the club starts running, it will be liberty reserved to have a recourse in law.
Forty-nine adjourned, seal number 50, to Satish KN.
Please, your lordship. Page 86. Page 86, my lord, is the direction issued by the learned single judge regarding extension of revision of pay scales.
Lord, I represent, my lord, all the respondent accused, my lord, in the matter. There is a direction by the Honorable the order of this Honorable Court, my lord, was modified by the Honorable Supreme Court. That order is at page 116.
116.
Begins at 116, my lord. The operative portion.
125 is the, my lord, relevant post.
Lord, pursuant to this, Lord, we had to do the exercise, my lord, of evaluation, my lord, that the entire process is almost complete, my lord. My request is grant us maybe a 10 days time, my lord. Within that, my lord, the entire process will be completed.
In course of the submissions from a learned advocate to the respondent stated that the original directions of learned single judge contained in order dated 4th November 2020, which are made subject matter of this contempt petition, were later modified by the Supreme Court in
Writ appeal as well as Honorable Supreme Court.
Order dated
Page
28th of April 2023.
124.
Civil Appeal number 2702 of 2023, as per order dated 28/4/23. It was submitted that the respondents have been carrying out the exercise of implementing the directions as modified by the Supreme Court, and the same will be done within reasonable time, put up on 25th of July.
Great, sir.
They are 10 days time, my lord.
Will comply and
Please.
10 days more.
Oblige.
51 urgent, cell number 52. So 50 ODR.
I appear for petitioning. Deficit court fee I have paid today morning, your lordships. There was mistake on my part. There was deficit in paying the process fee that I have paid in respect of 3 respondents. Today morning, I have paid. Subject matter is that, your lordships.
Is PIL?
PL.
Yes. File.
On 7/3.
My lord, I've made an endeavor, my lord, to see that the fund is removed. But what has happened is with the rains, my lord, the next year B photographs. My lord, with the rains, what has happened, the water has stagnated, my lord, but I have requested the officials to see that it is removed. If my lord could grant me 2 weeks' time, my lord, I may be able to submit, my lord, whether we have removed the bund or not. Notice had to go to, my lord, the concern.
This, the bund means the way which is seen is to be removed.
Yes, yes.
They have formed a road in the middle of the
It is-
tank,
It's,
It is in the pond.
yes, yes.
in the middle of the
Lake.
middle of the lake.
My lord, notice will have to go to respondents, 7, 13 and 23. But anyway, I've made my endeavor, my lord.
The allegation in this public interest litigation is that a bund in the nature of road is extended to divide the lake and in a bid to attempt, in an attempt to encroach the land by the private respondents, full stop. Notice was received on
7/3/24.
7/3/24. Also, today when the petition comes up for consideration, learned additional government advocate, Ms. Neelofar Akbar, fairly stated that she has instructed the authorities to ensure that the bund is removed and the lake area is kept made open. However, it was submitted that due to rains,
Yes.
the work of removal of bund is obstructed. She seeks further 2 weeks' time to
Obligement.
take necessary steps and instructions. Put up on 23rd of July, 23rd July.
Number 53.
Appearing for respondent board, your lordship.
I had sought for a direction. Lords to grant my lord's consent for operation. By the
Your
respondent.
lordship.
But
Sorry.
Yes.
Apologies to indulge your lordship. Senior is not available. I've requested the opposite side counsel. It may be taken up next week, your lordship. There are medical reasons due to which he's not
There is
available.
some urgency in this matter.
16th of July.
Lords, little bit earlier date if your lordships can kindly.
Will not be.
I know, my lord, it is covered by your lord, judgment of the dishonorable court.
It
It
was
is
heard.
covered. It is covered. EC, my lords, is deemed to have been granted. Lords may kindly correct.
It is heard.
It is not heard, but
Your lordship, it is not heard. The facts are different, your lordship. An earlier date may be given.
little bit earlier. This is a division bench has already ruled in my favor. One page synopsis, my lords, kindly permit me to place it.
12th.
Grateful, your lordship.
May I place synopsis, my lord? Shall I find? May I place synopsis, my lord? One page. And also the judgment of government bench. That they say once 45 days time limit is over, then my lords, the deemed EC will operate.
We are keeping in record, but better you argue and then
Very.
keep in.
They have given copies and they done.
Number 54.
My lord,
Yeah,
I
come
appeal
again,
for
we
the
will-
petitioners.
Respondent number
All
12 in
the
this matter.
students will-
Respondent number 12 in this matter.
My lords, I have filed application for impleading one of the college, that is Ambedkar Medical College, who have agreed to take 3 students in their college.
they are ready to give the admission. The facts of the case, my lords. Sixth respondent admitted 150 students illegally without NMC approval, my lords, for the academic year 22-23. My lords, when the KEA, Karnataka Examinations Authority, and the Director Medical Education uploaded the name of the college, and KEA granted admissions. And now, my lords, what is the after NMC, when the students moved the court, this honorable court, and this honorable court made interim arrangement and directed KEA to conduct counseling, because my lords, NMC had approved transfer of all these 150 students to other colleges. My lords, now all these 150 students have been transferred to 24 different colleges, private colleges. Now only these out of 150, 30 students are in trouble, my lords. Here in this petition, 19 students. Where they are now, what they are saying is that DME kindly see, my lords, in the first instance, neither at the time of KE reallotment counseling, nor after that.
So pleadings are complete?
My lords, this honorable court, my lords, directed the colleges, because we have made colleges. Now the problem is not the colleges, my lords, they are ready to take. The director medical education.
My lordship.
You file your statement of objection.
No, not at my lordship. Press
When-
time to file our objections, my lordship.
When
They
you-
served the copy. I seek 1 week time, my lordship. I need to
Lords,
take
my
instructions.
lords, my lords, they are not, Ambedkar College?
No.
My lords, I am asking for implement, application to be, a notice to be issued, because the urgency is, the examination is starting by first year supplementary from the last date is 4th of July to pay the amount. Therefore, my lords, they have to be admitted and they have to take registration number from other colleges.
Day after.
And my lords,
Implement.
already
See
the
that implement I.
IA is already filed. It was filed on 7th of June, my lords.
Impleading, yes, 3 of 20.
Because they have agreed to take 3 students. My lords,
So implement may be granted.
Pardon?
my lord.
Implement may be granted and notice to be issued to the said police.
And my lords, we will take hands, we are ready to take serve the copy by hand summons, my lords. May I request, my lords, there are few more students. The colleges have taken, already given admission because of Director of Medical Education's direction now issued. They are now not. My lords, the students, some of the colleges are ready to take, my lords, because of the direction issued by the Director of Medical Education. They have now withheld everybody's, and now, in fact, they are struggling, my lords. They are not even attending classes because of the direction. Kindly see, my lords, page number. Annexure A may kindly be seen, my lords.
No, today it is not possible to take up. We'll-
My lords, it may be taken up on next
First.
Monday.
Monday.
May I make a submission? My lord, may I make a submission? The other students of the same college as preferred in expedition seeking a similar prayer. So I request my lord to kindly correct those matters along with it.
No, they are listed, they are going to be listed when? Or,
My lords, other similar
on
matters.
first we'll see. Today at least, you are making us clear about this controversy. Yes.
Bill number 54, my lord.
We may be permitted to take hand summons, my lords, on the proposed respondent.
You tell us
Hands-
what is the controversy, what is the fact? You start in the.
My
you
lords,
board
fact
in
is,
the board bus in the middle.
no, my
Is not
lords,
so.
The facts,
Make us board the bus in the middle.
no, my lords, the facts are, my
I
lords.
just mentioned two lines, my lord.
Yes, yes.
The particular college did not have permission. In fact, there was a ban order on the college to make admission.
So excess in excess they had.
No, no, no.
And despite a ban order, they made admission. There's a specific ban order for that year not to make admission. Notwithstanding that, the KEA and DME went ahead, all three of them went together and made admissions through the admission process. Thereafter, a division bench of this court set aside all those. And then they have to be, naturally, they have to be now transferred out from that college into different colleges. There were two options. Either the state government they would have been transferred to state government colleges, or they transferred them into private colleges. They transferred them to private colleges. So whatever fee that they were paying there, they would pay to these, because these colleges, 24 colleges where they were sent, for them it is a bonus. They just have to sit in those classrooms, because we are not increasing their intake. But we will recognize NMC. We will recognize those from all those colleges, because they are in excess of the intake. But we will recognize them. What the DME has done is trying to fish in troubled waters. He has said there was one notice that the fees that were notified earlier by this college, which is the recalcitrant college, was a higher fee of 20-30 lakhs. Because no permission was given, when it came to making admission, it notified a lower fee and gave admission at 12-13 lakhs, because it had no permission from the NMC. So the official fee was 10-12-13 lakhs per year. So when they get transferred, the fee payable in the first letter written by DME is whatever fee was being collected, that would be the fee. Then the DME thought and became little wiser in collusion with the, whatever it may be, I need not say more about it. He said the fee that was fixed and notified, that cannot be. So that fishing in troubled waters created this problem. Now, my lord, solution. 2, all these colleges are getting a bonus, 1 crore per year they'll get. All of them will take it if the DME does not, but the DME is holding them back. So that's one aspect of the matter for my lords to consider. The second aspect would be the government will generate revenue of almost 15 odd crores, which can be used in their colleges. If these colleges, but for that, this court will have to wield the stick. Either the private colleges take them, or we will send them to the government college and pay the private college fee. All the students put together in the college, existing 100 seats in a government college, will not be paying that, which fee these extra students will put extra chairs and sit in the class there, which NMC will recognize. So it's a very simple thing there. But one authority is playing mischief. On Monday, my lord, when it comes up, we'll see. It's a small thing. They have to be transferred, because as per the essentiality certificate that is issued by the state government, it is their duty that if the college fails, these students have to be accommodated somewhere. So it's a very simple issue, but it has been made troublesome by, in fact, in one of the cases against the KEA, the NMC got a direction of a 5 lakh rupee cost. And when they went up in appeal, His Lordship Justice Gawai said, we will add 1 0 to that.
Lords,
So
in this
these are some of the
impleading
authorities'
application
actions.
is- Impleading application is, my lords, one of the colleges on humanitarian grounds, because the allotted college rejected to take them because of a DME direction. Therefore, my lords, they have given a letter saying that we are ready to take 3 students.
Monday.
Much of that.
Three petitions, my lord, which are connected, my lord, kindly be.
One, this we have not understood, we are giving three.
Similar matter, my lord, similar matter. Same colleges, my lord, same colleges, same issue, same.
All
players.
right, notified on Monday.
On Monday, the date. Along with just Monday date, memo for posting.
My lords, there is, I may be permitted, there is one more, should have been connected to this, it is daily.
One more to be notified.
No, my lords, already there is an order in that. They used to come together only, my lords. I'll give the number, my lords.
There is on record that the learned advocate general at one point of time had said, I will try to sort out this problem. However, because the learned advocate general had hitherto been one of those who was appearing only for private medical colleges, my lord, I think he decided to, it's part of the order. It's part of the order sheet. That's why I'm mentioning it. But it's not necessary to say all that. It becomes a little, we go off on a different track. The whole idea is that these students have to be now 6 months. They've not been studying.
Seal number 55. Shays Jessima.
The petitioner in this case, my lords. Challenge, my lords.
Any urgency?
Lords,
Urgent. What is it about?
lords, the building which is on the property, my lords, which I own, has been,
Reply is filed? Who appears?
notice has been issued, only dispatched yesterday, my lords. That is what the cause says. The impugned notice has to be stayed, my lords.
Notice hasn't been sent to the government, my lord.
So you're challenging notice at page 38,
Page 13, my lords.
13 or
Please.
38?
There are two notices, my lords. Earlier also the same notice was issued, my lords. Then a revised proposal also was submitted to the department, my lords. But even after that, my lords, the impugned notice has been issued, my lords. We're challenging both the notices.
You are challenging the notice at page 38, not 13, Mr. 6/1/24.
To that effect, my lords, we'll file amendment application, my lords. That has been missed, my lords, by oversight.
So you make good the violations and notice will be.
Lord, my lord, the revised proposal was given, my lords. That is in accordance with the, my lords, gazette notification, my
reply.
lords.
My lord, we haven't been served a copy.
Lord, copy will be served, my lord. We have already served while filing.
Reply, come office, reply come statement of objections, if any.
It's a date
Will
maybe
be
fixed.
filed within 3 weeks, put up on 5th of.
This matter, notice also hasn't been ordered.
Hold
to
it,
the government.
hold it. Notice is issued
Notice has been ordered only to the respondent. my lords.
on 30th 5/24.
But we'll serve a copy.
You copy.
Please, we'll serve.
Given the cause title.
You can, will issue,
Cause list doesn't show that it has been.
will issue fresh notice and you can accept.
Please.
Fresh notice to respondents, learned and advocate Ms.
Shweta
Shweta
Krishnappa, my lord.
Krishnappa accepts notice on behalf of
Respondent one.
respondent.
Only sole respondent, my lord.
In order to enable the respondent to file statement of objections, tend over to 6th of August.
Please, it's a earlier date, my lords. Earlier date may be fixed, my lord, because what has happened.
There is nothing, you are against no notice.
Lord, what has
His
happened?
only notice is we are prolonging the matter, otherwise good enough to dismiss.
Lord, they've said that either we have to demolish or else they'll file a.
We do good thing or bad thing.
Lord, we have come.
Something if it be done, then we'll dismiss the matter.
Lord, what is?
It is very good to dismiss this matter in our perception. But since notice is issued, we are prolonging and asking the other side to file a reply.
Please.
Don't.
Much of.
This furnishing of process fee, etc. Seal number 56. Mr. Vijay Raghava Sarathi.
7th August.
Seal number 57 urgents. 58. It's a final disposal matter. The Sachin BS.
Hearing for the state, my lord.
Appear for the 7th respondent in the first matter.
So I appear for the petitioner.
My prayer is to direct respondent number 7 to prohibit from proceeding with the construction of new market building, my lords.
So market building is constructed,
Proposed market building falls under the area of
it is constructed or not?
It is half constructed, Bala.
Not constructed.
Now the municipality called for tenders for putting up construction of a market complex. The persons who were doing business in this vegetable marketing and other things, they were asked to do it on the street till the market complex is completed. Now the market complex is half completed, nearly 10 crores have been spent. Now at that stage, my lord, they filed a writ petition saying that this comes within 200 meters from the ancient monument. We said we have no difficulty, you may conduct survey, any safeguard is to be done, we are prepared to comply with that, any direction given by the Archaeological Survey of India. Then also, my lord, they say you have not taken previous permission, therefore we will not be able to give permission. There are nearly 200 buildings, my lord, which have been constructed nearby, wherein they are not taken any action. Now the building constructed with the municipality is now, my lord, huge public money has been spent and it is half constructed. We have not been able to proceed in the matter
Because of this petition.
because of this case.
So any stay order is granted?
There is a stay order granted, then, my lord, this court also directed the Archaeological Survey, please conduct inspection if there is any, does it harm the ancient monument or not?
It is-
Then also, my lord,
Ancient monument is within prohibited area. They are this construction.
it's about 200 meters, about 190 meters from this building, which is
My lords, so
195
far as
meters.
that submission-
What is that monument?
Lord, that is called as a Chowta's Palace. Chowta's Palace. It is called as a old palace.
Old palace.
Old palace,
Chowtar Palace, yes.
Yes, it's not the palace.
palace construction.
This is the, it is.
Palace.
A courtyard.
That is the
In,
court.
inner courtyard.
Page number 19 of my petition.
Century building, my lord.
The building is not a monument. Inner courtyard is the monument, declared monument.
Let's kindly see page number 19 of my petition, my lords. It has mentioned that the list of monuments in Karnataka.
Restricted.
Where at page 26,
100 meters prohibited. 200 meters. Totally 300.
So this proposed marketplace is how far from this monument?
This is comes out to 195 meters from that area.
And what is their prohibited zone?
That is 200 meters flood, 100 meters according to this act. 100 meters is prohibited area. 200 meters thereafter is regulated area where they can give permission for putting up construction. This comes within the regulated area.
Regulated area.
Regulated area. That is why we made a submission that since it comes within the regulated area, please examine whether permission can be given or not. That also they are.
It is at Bangalore.
No, this comes flood in Mudbidri near in Dakshin Kannada. That is-
Mudubiri town. Where is that?
This is about 60 kilometers from Mangalore.
Who appears for archaeological?
40 kilometers from Mangalore.
Archaeological department, who appears?
lords, if I'm not wrong, Madhukar Deshpande sir was appearing for Archaeological Survey of India, my
Where
lords.
for municipality?
Lord, I am for the contractor, my learned friend is for the municipality. I participated in the tender, I have invested huge money. And the entire construction is
And
halfway.
in the connected writ petition at 4829, my lord, this honorable
Please.
court permitted the construction to go on. That is also placed before this honorable court.
Me appearing for the learned counsel in point 14829. Since there was interim order in the other case, the same was to apply to this case also, my lords. And the second matter, the award of the contract is under challenge. Mainly on the ground, my lord, that though the value of the subject matter was itself huge, and it's mentioned in the admitted documents, value is 25 crores. And the time given for inviting the tenders was only 30 days. And then was unilaterally extended by an authority who was not competent. And award is given to the only person who came there, subsequent to the period mentioned in the publication. This is violation of Rule 17. Award of the tender itself is illegal opposed to law, apart from other illegalities, my lords, which is borne out from other writ petitions. In my writ petition, Annexure B is the paper publication, my lord, issued by the Mudvidri Municipal Council. The date of the publication is 21/12/2016. Last date for the proposal to submission of the tenders is 20th of next month. That's less than 30 days. And in fact, it should have been minimum 60 days as per Rule 17. The value is 25 crores.
So you are for whom? EP.
In point 1, my lord, sir,
You are for
By the-
whom? Which respondent?
That is the second petition for.
for the petitioner, for the learned counsel for the petitioner.
Second petition.
That is also PA.
Lord, may I pass on the building photo?
There was an external report also sought for, my lord.
It is given, but
No, first also it was given. Second time also it's given. They say that there is no.
Only that if market is constructed, there will be a traffic and
yes,
pedestrian.
after the completion, my lord, we have to give it to vegetable vendors and others. The municipality has proposed this project. After construction, it will have to be allotted to vegetable vendors and other small petty shops.
So there will no traffic problem.
My lords, that point has to
There
be
is no
answered. by
traffic
the-
issue is not there at all. In fact, my lord, we have produced a heritage impact assessment report where they say that there is no impact on the ancient monument. And in fact, my lord, all other buildings are being constructed. Only municipality's building has come to a standstill. In fact, I have given a report how many buildings have been constructed even within the prohibited area. I am only saying.
So submitted at R30.
Yes, my lord, now
But where is that?
that report.
2019,
You give the list of the reports submitted and the gist.
2019 page.
My lord, when the matter was going on, again, this honorable court directed that a re-survey has to be conducted and also impact assessment report was filed, that is placed before the court. On the basis of the impact assessment report, respondent number 7 filed an application for modification vacating the interim order. At that stage, now all these to be considered because impact assessment report is there is no impact of this building on the monument because monument is only report is
2000,
This
uh,
impact
It is,
assessment-
it is kept in the
Additional
file.
objection. Yes, it is there, impact assessment,
2019 June, my lord.
875. So this we can dispose of, dispose of.
Can be
Yes.
disposed of.
57 of the report, my lord.
Lords, in this matter,
that
if
is
Archaeological Survey of India has
57.
no objections, my lord, matter may be disposed, my lords. Because Archaeological Survey
But
of
today
India should
we'll
answer,
just
my
go
lords.
through and
Because, my lord,
Page
project
57 of the report may be kindly seen, my lord.
you no objection.
My lords,
In
Archaeological
fact,
Survey of India.
they had filed a memo before this honorable court to withdraw the petition. That is also on record.
That I have no knowledge, my lords. I'll clarify.
Why don't you,
They
why don't you
themselves.
withdraw? A good market may come up for small vegetable vendors. It's a small town or big municipality? Municipality?
Municipality.
Small municipality.
My lord, the small,
Local area.
yes, municipality, small vegetable vendors were doing business. And because
Today there is no market.
there is no market. And
Earlier
they are,
market is demolished
Yes.
and new market is to be constructed, it stopped in the halfway.
and they are
In the
placed
next week,
in
my
the-
lords, I'll seek instructions, my lord, because I cannot answer.
Take
them.
instructions.
My lord, the
Or
heritage.
In the
is-
meantime, we'll go through. With 10th, 11th we'll keep, 11th.
Please.
That's
The
subject to what
heritage-
your lordship say, that this existing structure also is getting
No,
dilapidated.
we'll finally dispose of, don't worry. If prima facie appears that deserves to be permitted,
the
subject to,
heritage impact
subject to, of course,
assessment
further
report,
examination.
my lord. Page
11
56.
बहुत है।
It gives the conclusion and the recommendation.
बड़ा है, तो रख दे।
Filed on June 2019.
Come on, 11th, 11th will do.
2:30, Malak? 11th at 2:30?
All at 2:30.
Obliged. Obliged.
Case number 59, the final hearing matter.
Respondent.
My lords, appearing for the petitioner, my lords, there is some inconvenience, my lords. My senior is unable to appear today. It may be had after the 10th of next month, my lords. I'll be grateful.
There is some urgency, my lord. Nearly 4 times it is adjourned.
What is it about?
This is a case, my lord, where the earlier round of litigation, this court directed that a land should be allotted to us. Pursuantly, land is allotted. Now they are questioning once again the allotment of land in favor of in a PIL. The land is allotted in our favor pursuant to the direction of this honorable court. Allot. 347, Allah. In fact, BDA has also filed an affidavit.
They are seeking time, but let us.
My lords, if I may make a submission, we filed our written submissions as well, my lords. Only hearing is pending. Final arguments, if it may be taken after the 10th, I'll be grateful, my lords.
Thereafter, 23rd.
Obliged, my lords.
May kindly be posted at 2:30, my lord, for specific, 2:30. 2:30 on that day, my lord. Because of some urgency. I purchased the property, my lord, in 2014. My lord,
Without applying mind, we will not keep it to third. On that day, we'll apply mind, and thereafter in September, we'll keep it to third. Not possible to take up whole matters in that way. Let us see. On that day itself, maybe we may dispose of. But let us apply mind.
Last almost 10 years it is.
We are
pending.
aware.
That is why
We are aware, but
it's submission. If your lordship can
take chance,
it up
not
at 2:30 on that day.
15th of July, take chance, 15th of July. 15th July. Take chance.
Ananya K. Chandar, number 60.
My lords, I appear for the petitioner's counsel in this matter.
Yes.
My lords, the matter needs to be heard. My lords, pleadings are all complete. We are ready, my lords, whenever you lords have time. My lords, in this matter, my lords, we have challenged the validity of the Akrama scheme brought out by legislation.
25th of July. Yes.
Number 61.
ಎಲ್ಲಾಗತ್ತೆ ಬಿಡ ಎಲ್ಲಾಗತ್ತೆ ಇವರು
I appear for the appellant, my lord. Matters for final hearing, my lord. Sometime I'm ready to address arguments. Matter may take some time.
The employees are claiming additional increments for having acquired higher qualification. Whether they are entitled or not is the issue for consideration.
My lord, there was, in the regulation, my lord, there was a provision for the board, electricity board, as it then was, to pass an order to provide for additional increments for obtaining higher qualification. Under that, my lord, there was order issued, and my lord, it permitted the employees, my lord, to pursue, my lord, MBA degrees. And my lord, if they have completed within the time frame, my lord, they were entitled to either 2 or 1 increment, depending on they were entitled, my lord, to 1 or 2 increments, depending on whether they acquire the degree at their own cost or at the cost of the institution. Now, my lord, subsequently, it was found that many of these employees were getting degrees from institutions on correspondence basis, and from institutions, my lord, which were not recognized. And also, my lord, it was found that this entire process was not helping the organization in any manner. Therefore, my lord, the decision was taken to withdraw the order which permitted the organization to provide increment. That was made subject to ratification by the board of directors of the company, because in the meanwhile, the electricity board got incorporated by virtue of the statute into a incorporated company fully held by government of Karnataka. So, my lord, subsequently, the board has ratified the decision to withdraw the order. Now, after, my lord, the withdrawal of the order and before ratification, my lord, the petitioners say that they completed the degree. And they made a representation to say that the earlier proposal, which was there for granting of additional increments, that should be revived. Pardon? Yes.
The only thing is, some of us are retiring. Some
They have
of us
already
are
retired. Many of them have retired, my lord.
Many of them have retired and some are still going to retire. Some early date, my lord, your lordship. We are apprehensive of asking for much more earlier date because your lordship will give still longer.
Case number 62, Mr. Satyanand BS.
62, my lord, 62.1 in both the matters. Second matter is the main matter, my lords. My construction, corporation road is encroached and my construction is stopped from the last 14 years, my lords.
My lord, I would like to make a submission with regard to the second matter, 62.1. I'm representing the Mr. Ganesh Bhatt to Appliance Council, my lord. His wife is admitted to hospital, so he wants a small accommodation, my lord.
It will go to some other date, Mr. Council.
Please, ma'am.
Lord, may I request for extension of the interim order in this matter? Please.
29th of.
Well considered order of the single judge, which will go a long way in administration of the BBMP. Some accommodation, my lord, sorry.
29th,
Short.
29th July.
Grateful. Ma'am.
Please.
Next matter, that interim order may kindly be extended. 64. Next.